55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good morning. You may be seated. Calling the case of People versus Lauren Dean Robinson. Or do you want to do another case?
I think that would be fine, Your Honor. Thank you.
Thank you. File 20-6309-FH. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the people.
May I please support Scott Moore for the defense?
Does Lauren Dean Robinson appear here today? The record should indicate no response. The record should further indicate that at one point this case was scheduled for a final pretrial conference to occur on June 15, 2021. On that day, the defendant failed to appear. The court then scheduled a show cause hearing for today to show for the defendant to appear and show cause why he should not be held in criminal contempt of court for allegedly failing to appear here in court as ordered back on June 15. Now on June 21, when the defendant was ordered to appear here at 9 a.m. It's now approximately 1/2 hour past that time. It's 9:20 p.m. by the court's clock. The defendant still has failed to appear. Do you know of any reason why that is the case, Mr. Moore?
I'm afraid I do not. At the last hearing, I've made something of a record of our attempts to contact Mr. Robinson. Since that time, we've made phone calls and sent text messages.
Very well, then the court will revoke and forfeit the bond in this matter and issue a bench warrant for Mr. Robinson's arrest for him to be brought before the court to show cause why he should not be held in criminal contempt of court for his failure to appear here today and his previous failure to appear here in court back on June 15. Bond on the bench warrant will be set in the amount of $4,000. Cash only will be posted only to defendant's own name. To reflect it's now 9:31 a.m. by the court's clock, and the defendant still has failed to appear. Calling the case of People versus Joshua Joseph Eaton, file 21-6604-FH. Would counsel identify for the record, please?
Montana People System Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
And please support Scott Moore for the defense.
And Mr. Eaton, would you please raise your right hand to be sworn, sir?
Mr. Eaton, I do need you to unmute your microphone, please. Thank you. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name, sir?
Joshua Eaton.
You may be seated if you'd like, Mr. Eaton. Mr. Eaton, you appear here today for a pretrial conference. How did your client want to proceed in that regard, Mr. Moore?
We'll be proceeding to trial.
Very well, then, Mr. Eaton, do you understand, sir, that according to count 1, you are charged with criminal sexual conduct to degree?
Yes, I don't understand why, but yes, I do.
Okay, well, the important thing is, do you understand that that's what the charge is?
Yes.
Do you understand also, sir, that that crime is a felony and it carries a maximum possible sentence of life in prison or any term of years in the state's prison, and the minimum sentence would be discretionary with the court, although there would be a mandatory prison sentence. Jail or probation would not be an option. And in addition, there would be mandatory lifetime electronic monitoring and mandatory AIDS and sexually transmitted disease testing. And also, this is a tier 3 offense under the Michigan Sex Offender Registration Act. You understand all those things, so.
Your Honor, if I may interrupt,
Sure.
I see that the prosecutor had sent a pretrial summary to me over the weekend. I'm going to state this for my client, and I would ask the court to reschedule this matter for a status conference in light of the offer that's been made.
Sure.
Mr. Eaton, I'm not asking you to make any decisions right now, but I want you to understand that the prosecutor has significantly improved the offer from where it was the last time we spoke. Right now, she is allowing you to plead either guilty or no contest to the crime of criminal sexual conduct in the 3rd degree. That is a 15-year felony. It has a number of other collateral consequences that we need to discuss, but she has removed her requirement that you plead guilty to the life offense and is allowing us to consider pleading to a 15-year felony. For that reason, Mr. Eaton, I'm asking the court to adjourn this hearing to a status conference so that you and I can go through this very carefully, and then you can make an informed decision about how you want to proceed. Does that seem fair to you, sir?
Yes, sir.
Very well, thank you, sir. Then we'll schedule the case for a status conference at 9 a.m. on Monday, July 19. Will that give you sufficient time, Mr. Moore?
Yes, Your Honor.
Very well, then, the bond status will be continued. The case is adjourned to the date and time indicated.
That was July 19th, correct?
Yes, sir.
Thank you. We'll be in touch, Mr. Eaton, very soon.
Okay, that's it?
For now, thank you.
Calling the case of People versus Judith Elizabeth Conaway, file 21-6606-FH. Would counsel identify for the record?
Morning, Your Honor, Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
Today is the date and time scheduled for a pretrial conference. Are we on the wrong case?
Mr. Doss is waiting for his turn.
Thank you, Mr. Moore. Thank you, sir. Today is the date and time scheduled for a pretrial conference in this case. How did you want to proceed in that regard, Mr. Moore?
Your Honor, I would ask for this matter to be scheduled for a status conference. I know that Ms. Conaway had contacted my office on Friday, indicated that she would be here today. She also indicated that her living circumstances have changed dramatically regarding the ability to talk on the telephone or maintain transportation. The prosecutors made an offer that certainly bears closer consideration, and I don't believe that this matter will go to trial. So if we can set this for the 19th, hopefully we can get this wrapped up.
Any objection, Mr. Webb?
No, Your Honor.
Very well, we'll schedule a status conference in this case at 9 a.m. on Monday, July 19, 2021. The bond status will be continued unless ordered otherwise. I would ask that the defendant be here in person on that day.
Okay, thank you, Your Honor. I just said okay on the record. I'm very sorry. I apologize.
Well, calling the cases of People versus Johnny Dwayne Doss, file numbers 2021-6611 and 6612-FH. Would counsel identify for the record, please?
Morning, Your Honor, Mark Webb on behalf of the people.
May I please the court, Scott Moore for the defense. I'm not certain that we're proceeding on a plea today. In fact, Your Honor, if we could approach the bench.
Sure.
Multitasking.
It's not the usual procrastination. We're actually trying to get something done. Why not? Okay, sure.
You want to take that day off?
You too.
The court has conducted a sidebar conference with the Assistant Prosecuting Attorney, Mr. Webb, and the Defense Attorney, Mr. Moore. The court will schedule a status conference of these two cases for 9 a.m. on Monday, July 19, 2021. The bond status in each case will be continued. The cases are adjourned to the date and time indicated.
Thank you, Your Honor.
Thank you, sir. Calling the cases of People versus Dominic Ryan Tyler, file numbers 2021-6652 and 6655-FH. Would counsel identify for the record, please?
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people in case file number 21-6655-FH.
Your Honor, Mark Webb, on behalf of the people in 21-6652F.
Today is the date and time scheduled for a pretrial conference in these two cases. How will we proceed in that regard, Mr. Whitmore?
Thank you, Your Honor. I know that Mr. Tyler stopped by the office last week to pick up some discovery. I know that I received a text message from him this morning at 6:40 a.m. Stating that we knew that we had court today. I responded to it at 9:14 from my cell phone indicating that he should be here. I asked my secretary to send messages to him containing Zoom information as well as the notice that he needs to be here. So he knows about it. He has been substantially compliant with my request for communication. Instead of asking for a show cause hearing, as this is a pretrial conference and it appears at the moment we are proceeding to trial, I would ask the court to conduct the hearing without his presence. And if parties believe that a status conference or a plea date would be appropriate, that we bring it in earlier. Otherwise, I'm going to ask for this simply to be set out jury trial.
Well, the court is not entirely comfortable, in fact, I'm not comfortable just putting the proceeding with a pretrial conference in the defendant's absence, especially since he was ordered to appear here today. And based on what you've indicated as an officer of the court, Mr. Moore, the defendant appears to have been well aware of today's hearing, and you specifically instructed him approximately half an hour ago to be here. If this case was scheduled to be heard at 9 a.m., it's now 9:42 a.m. on the court's clock. What I will do is I will schedule the pretrial conference. I'll adjourn it from today until Tuesday, July 6th at 9 a.m. At that point in time, we also will delve into the reason, if any, for the defendant's failure to appear here today, and whether his bond should be forfeited and whether he should be held in criminal contempt of court for his failure to appear here today. Those are not matters the court has to decide right now. It's 9:43 a.m. by the court's clock. The two cases are adjourned in the date and time indicated.
Thank you.
Thank you, sir. Sure. Let's.
Mr. Schaefer, can you unmute your microphone, please?
Yes.
Calling the case of People versus Zachary Ian Schaefer, file 21-6583-FH. Would counsel identify for the record, please?
Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
May it please the court, Scott Moore for the defense.
Sir, are you Zachary Ian Schaefer?
Yes, sir.
Previously in this case, back on May 17 of 2021, you appeared in court, and at that time you pled guilty to the 10-year felony crime commonly known as possession of methamphetamine. You appear here today to be sentenced. The maximum penalty the court could impose is 10 years in prison. The minimum sentence is discretionary with the court, and the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 11 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Mr. Schaefer?
Yes, I do.
Mr. Moore, have you gone over both of these reports with your client?
Yes, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
Okay.
Do you have any challenges to the scoring of the offense variables or prior record variables, or the calculation as to the applicable sentencing guideline range being 0 to 11 months?
Okay.
On behalf of the people,
Chief Assistant.
Ms. Schwartz, I pose the same questions to you, Ms.
Yes, thank you, Your Honor. We have no objection to the scoring of the guidelines. We think they're appropriately scored. We have no corrections to the pre-sentence investigation report, and we ask that you follow the recommendation.
Thank you, ma'am. Mr. Schaefer, do you have anything you want to say on your own behalf before the court imposes sentence?
I just want to apologize for wasting your guys' time. And I'm looking forward to putting this past me.
Thank you, sir. And on behalf of your client, Mr. Moore?
Thank you, Your Honor. There was a plea agreement on this case. Defendant to be granted 7-4-11 status of eligible. It appears that he is. So we would not need to proceed. But overall, we believe that the recommendation made by the Department of Corrections is appropriate and will serve the interest of the public at large, as well as my client's personal recovery. The only concern that I have regarding the proposed order of probation at paragraph 19, special condition 5.0, indicates that the defendant must not drive a motor vehicle unless first obtaining written permission from the field agent. There could be a rational basis for that requirement. However, it is our understanding that if the agreement is followed and he is granted 74 allowance status, there would be no adverse action taken against his driving license. So I would refer to the people or the Department of Corrections if they're of a mind to provide at least a rational basis for this requirement. Because I've seen this only in matters where licenses were suspended pending further action by the Secretary of State. Thank you.
Thank you, sir. And I shouldn't speak for the prosecutor or the probation department, but I don't think the department is indicating that the Secretary of State is to take action against the defendant's driver's license, although the recommendation, at least as listed in paragraph 19, would be to the effect that as a condition of probation, the defendant must not drive a motor vehicle unless he first gets written permission to do so from the probation agent. And appearing on behalf of Clare County Circuit Court Probation Department, is there an agent? Hi, thank you.
Agent Katie Brubaker, Your Honor.
Thank you, ma'am. Do you, Ms. Brubaker, is this your pre-sentence investigation report, ma'am?
It is not, Your Honor. I believe Agent Adam Marty was covering, assisting Clare County with PSIs during this time when the defendant took a plea. He indicated like that condition added for his probation. I have no objection, Your Honor, with the further.
Okay, thank you. And if people have a position with regard to that clause of probation?
Your Honor, we take no position as to why it's in the pre-sentence investigation report, and if Your Honor wishes to redact that, we're fine with that.
Thank you, ma'am. Is there anything else in the report of factual nature you might add to explain or contradict, Mr. Moore?
Not at all. Aside from that anomaly, I thought that Agent Marty, who was pinch hitting from the Saginaw, wrote thorough and sensitive report, and we asked for to adopt those recommendations.
Anything further with regard to the content of the report, Ms. Schwartz?
None, Your Honor.
And Mr. Schaefer, is there anything further, sir, you wanted to indicate on your own behalf before the court passes sentence?
I apologize for wasting your guys' time again, and that's all.
Thank you, sir. And anything further on behalf of your client, Mr. Moore?
Thank you.
And on behalf of the people, Ms. Schwartz?
No, Your Honor.
Very well, sir. In order to punish you, what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself. It's the sentence of the court. You'll be placed on probation for a period of 1 year. And in addition to all of the statutory terms of probation, you must abide by all the written terms of your probation order as well, which include but are not limited to: you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred, and give up any confidentiality right you have in any such program. You must not possess any weapons or copies of weapons, and you must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must seek and maintain full-time employment and or be enrolled in a full-time education program. And you must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must pay $68 in state costs, and you must pay a crime victims assessment in the amount of $130. Court cost of $500, a fine of $500, and court-appointed attorney fees.
Your Honor, we estimate fees to be $260.
Court-appointed attorney fees of $260. And further, you must pay probation oversight supervision fees of at least $30 per month, rising to $60 per month for any month during which you are on electronic monitoring supervision. Now, how much of that $1,700 or so do you have available today to apply towards your court-ordered money, sir?
I can apply at least 50 to 100 today.
All right, then you must pay at least $50 today by 3 p.m. today. And then you must pay an additional $100 each and every month. You must pay an
Yes, sir.
additional, you must pay an additional $170 per month, each and every month, with the first payment being due by 12 noon on August 1st of 2021, and an additional similar payment due in that same amount, minimum, by 12 noon on the first day of each month after that, until all this money is paid in full. But regardless, all of this money must be paid before you are off of probation. The second to the last question I have to make is whether to put you in jail or prison today. I'm not going to incarcerate you today. And we'll take a chance on you and hope that you behave in the future. The final decision I have to make is whether to grant the special status under Michigan Compiled Law 333.7411. If I don't do that, number one, you wind up with a felony conviction out of this incident. Number two, your driver's license will be suspended or revoked. I'm going to grant you the 7411 status and give you a chance to keep this conviction for possession of methamphetamine off of your record. Because I have granted the 7411 status, there is no need to advise you of your appellate rights, because they don't get attached, because I have not imposed the final sentence. But Agent Brubaker, do you have any additional instructions you want to give to Mr. Schaefer?
Yes, thank you, Your Honor. Mr. Schaefer, you need to contact Agent Nathan McConnell at this number. Do you have something to write this down?
Yes, ma'am.
989-329-9820. You need to call him by the end of the day today.
All right. Thank you.
Thank you, Your Honor.
Thank you, ma'am. Very well, we'll be in recess on that matter then.
Thank you.
Off the record. Just do it.
Thank you. Calling the case of People versus Alexander James Johnston, file 21-6569-FH. Would counsel identify for the record, please?
Assistant Prosecuting Attorney Lee Schwartz, appearing on behalf of the people.
This court's got no defense.
And sir, are you Alexander James Johnston?
Yes, sir.
Previously, Mr. Johnston, back on May 11 of 2021, you appeared in court, and at that time you pled guilty to the crimes of unlawfully driving away of a motor vehicle and also to being a habitual offender, third offense notice. You appear here today to be sentenced. Ordinarily, the maximum penalty the court could impose for the underlying crime of unlawfully driving away of a motor vehicle would be 5 years in prison, and the minimum sentence would be discretionary with the court. However, because you also pled guilty to being a habitual offender, third offense notice, the net effect of those two things is that the court, in its discretion, may double the maximum penalty from 5 years in prison to 10 years in prison. It would be discretionary with the court whether to double the maximum sentence or not. And regardless of whether the court doubles the maximum sentence, the minimum sentence would be discretionary with the court. Do you understand those things, Mr. Johnston?
Yes, sir.
The Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report and a sentencing information report. And in those two reports, at least thus far, the departments calculate the applicable sentencing guideline range to be 5 to 34 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Mr. Moore, have you gone over these reports with your client?
Yes, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
Not of factual nature, Your Honor.
Thank you, sir. Do you have any challenges to the scoring of the offense variables or the prior record variables or the calculation as to the applicable guideline range being 5 to 34 months?
The defense agrees with the calculation, Your Honor.
Thank you, sir. And on behalf of the people, I would pose the same series of questions to you, Ms. Schwartz.
Thank you, Your Honor. We have no objections to the scoring. And as far as the substantive nature of the PSI, I have no issues with. The only thing that I would note is on page 1 of the pre-sentence investigation report, it does show, I just wanted to make sure that the, never mind, disregard, I understand. No additions or corrections. Thank you, Your Honor.
Thank you, ma'am. And Mr. Johnston, is there anything, sir, you want to say on your own behalf before the court passes sentence?
No, sir.
And on behalf of your client, Mr. Moore?
Thank you, Your Honor. We've been asked the court to follow the sentence agreement that's been bargained for in this case. I would note, it appears that my client may be admitted to the Ionia County Circuit Court treatment court program. That's more for the court's information to show that it's making some efforts to get in front of the substance use and behavioral health issues that have contributed to this particular offense. As I said, we asked for the recommendation.
Thank you, sir. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. And on behalf of the people, Ms. Schwartz?
Your Honor, we ask that you follow the agreement in this particular case and add those special conditions that are identified in the pre-sentence investigation report as an order of the court.
Thank you, ma'am. Mr. Johnston, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court that you'll be placed on probation for a period of 3 years. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which include but are not limited to: you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse treatment program or mental health treatment program to which you are referred by the probation agent. Give up any confidentiality right you have in any such program. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must not engage in any assaultive, abusive, threatening, or intimidating behavior or possess any weapons or copies of weapons. You must submit to a search of your personal property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must pay $68 in state costs, a crime victims assessment of $130, court costs of $500, a fine of $500, and court-appointed attorney fees of
We estimate $400.
$400. Now, how much of that $1,600 or so do you have available today to pay towards your court-ordered money, sir?
I don't have anything available today, Your Honor.
Okay, thank you, sir. Then you must pay all of this money by the time you get off of probation, and unless ordered otherwise, you must pay at least $100 each and every month, with the first payment being due by 12 noon on the first day of the first full month after you're released from jail, and each additional payment to be made no later than the first day of each month thereafter until paid in full. Finally, you must serve 240 days in Clare County Jail, but you will receive credit for the 110 days already served. Now, it's my duty to inform you, sir, that you are entitled to appellate review of your conviction and sentence, and if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Do you have any additional instructions to give to Mr. Johnston and Ms. Brubaker?
Thank you, Your Honor. Mr. Johnston, upon your release from jail, you need to contact our department to reach out to your probation agent, okay?
Okay.
Thank you.
Thank you, sir. We'll be in recess on that. Thank you. Thank you.
Okay, can you unmute yourself and identify for the court, please?
Oh, there it is. It is.
Mr. Tyler, can you please unmute your microphone?
Yep.
Could you tell us your name, sir?
Dominic Ryan Tyler.
Recalling the cases of People versus Dominic Ryan Tyler, file numbers 21-6652-FC and 21-6655-FH. Would counsel identify for the record in this case?
Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
It's got multiple accounts.
Thank you. And Ms. Schwartz, are you appearing on behalf of the people in both of the two files?
I will, Your Honor, yes. Or I'll defer to Mr. Webb if he's there.
Thank you,
Yes.
Ms.
Thank you, Your Honor. Mark Webb on behalf of the people, file 21-6652-FH. Thank you.
Thank you. Today is the date and time scheduled for a pretrial conference in each of these two files. Are we proceeding by way of a pretrial conference or by way of guilty plea, Mr. Barr?
Pretrial conference.
Very well then, do you want each of the two cases scheduled for a jury trial?
Your Honor, I know that because my client had been exercising due diligence to log in but was unable to connect, this matter had been set for continued pretrial conference as well as a show cause hearing on July 6th. I see that I did receive at least one, perhaps two new pretrial conference summaries over the weekend. I'd like to take advantage of that rescheduled date to go through the offers with my client, determine whether to proceed with the trial or enter a plea on the 6th of July. That's not too inconvenient.
All right, we'll have a status conference on this case then at 9 a.m. And that's on Tuesday, July 6th, is that correct, sir?
Yes, Your Honor. And if I might be so bold, I ask the court to consider recognizing the client's efforts, as I've already stated earlier, the fact that it's here now and that the show cause hearing will not proceed on July 6th. It'll just be the pretrial conference.
That's what I will do.
Thank you.
Do you want the defendant to appear in person on that day, though?
I would, Your Honor, and going forward, I think it's far more efficient for all of the parties to be present in the courtroom as long as it's allowed by Executive Fiat. Yes, Your Honor.
Very well. What that means, Mr. Tyler, is you don't have to make a decision today about how you want to proceed. Apparently, an amended offer has been made, and your lawyer wants to have a chance to discuss all of your options with you, but you're going to have to come back and be here in person in the courtroom at 9 a.m. on Tuesday, July 6th, 2021. And at that time, there are some decisions you might well have to make. In the meantime, do you want to go ahead with the pre-trial conference or to conduct the pre-trial conference on July 6th as well?
I prefer to do that on July 6th. Thank you.
Very well, thank you, sir. Then I think that's everything, Mr. Tyler. Thank you for being here today. Make sure you stay in touch with your lawyer and make sure you abide by all the terms and conditions of your bond. Thank you, sir.
Thank you.
Ms. Poole, can you hear the court?
Calling the case of People versus Matthew Irving Horowitz, file 21-6546-FH. Would counsel identify for the record, please?
Morning, Your Honor, Mark Webb on behalf of the people.
Please, the court, Scott Moore.
Mr. Horowitz, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name, sir?
Matthew Irving Horowitz.
Thank you, Mr. Horowitz. Mr. Horowitz, today is the date and time scheduled for a status conference in your case. How did your client want to proceed regarding that status conference, Mr. Moore?
Your Honor, I think I'm missing a page. Of the offer of proof. We're going to have to reprint that. In that connection, Your Honor, the defense has received a copy of the information. We'll be reading the information. It's our understanding that we will be proceeding pursuant to count 1 of the charging document, waive preliminary examination. We'll be doing so by way of no contest plea. The parties have prepared an offer of proof. Looking at it now and I'm missing page 2 of that document. If we could print that and proceed on that.
Your Honor, I'll print that off in the law library.
Sure. Well, did you want to do that now or?
I'm doing it right now.
Thank you, sir.
I may have run to the back.
Sure, thank you, Mr. Moore.
Yeah.
Could you make a copy for me as well, sir?
I'm not sure if you heard you.
You Scott Moore?
Good morning. Can you hear me?
I can, who do you have there with you?
This is Isabella County with Thompson.
Thompson.
Well, this could take a few minutes. We'd be happy to pass for a
Give me
moment.
just one moment.
Sure.
Okay, we're not quite to his case yet. He's not scheduled, he's scheduled at 10:20, so I'm going to put him back in the waiting room until we're ready on that one.
Either way, Your Honor, we did find we found the offer.
Then recalling the case of People versus Matthew Irving Horowitz, you've been sworn to tell the truth, is that correct, Mr. Horowitz?
Yes, Your Honor.
Could you tell us your name?
Matthew Irving Horowitz.
Mr. Horowitz, do you understand, sir, that according to count one, you are charged with the 5-year felony crime commonly known as operating while intoxicated, causing a serious impairment of a body function or a serious injury?
Yes, Your Honor.
That crime is a felony.
Yes, Your Honor.
It carries a maximum penalty of 5 years in prison. Do you understand that?
Yes, Your Honor.
The minimum sentence would be discretionary with the court. Do you understand all those things?
Yes, Your Honor.
We'll just wait a few minutes. Do you understand that according to count one, you are charged with a 5-year felony crime commonly known as operating a motor vehicle while intoxicated, causing a serious bodily injury or serious impairment of a body function?
Yes, Your Honor.
That crime is a felony. It carries a maximum penalty of 5 years in prison and or a fine of anywhere from $1,000 to a maximum of $5,000. Do you understand those?
Yes, Your Honor.
Now, the minimum sentence would be discretionary with the court. And with regard to count one, you may make any of the following 3 pleas. Four pleas.
Thank
you. You may make any of the following 4 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. Third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. And fourth and finally, you may plead no contest, which means that you do not contest the prosecutor's proofs, and it amounts to a plea of guilty. Do you understand the 4 possible pleas that you may make to count one, sir?
Yes, Your Honor.
then answering to count one, what is your plea?
No contest, Your Honor.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, Your Honor.
The court also informs you that if your plea of no contest to count one is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and not have your silence used against you. But finally, you also do have the right to testify at the trial in your own defense, And if you choose to do so, then your testimony would be considered in the same manner as the testimony of the other witness. Do you understand all of those rights, sir?
Yes, Your Honor.
And do you understand that by pleading no contest to count one, that means you'll be giving up each and every one of those rights?
Yes, Your Honor.
Now, I'm going to ask the Assistant Prosecuting Attorney, Mr. Webb, and your lawyer, Mr. Moore, to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement in this case?
Your Honor, if I might,
Sure,
I'll
thank you,
defer
Mr.
to,
Moore.
Mr. Moore.
Thank you, Mr. Webb.
for the first time in 25 years, the defense attorney actually was the one who placed it. You switched us up, you went over to him. Your Honor, it's our understanding that in exchange for my client's plea of no contest to count one of the information, after sentencing and passage of the applicable appeal period, count two would be dismissed. Further, there is an agreement as to sentencing pursuant to the cases of People versus Briggs and Killebrew. Initial incarceration, if any, would be capped at the midpoint of the MDOC guidelines as prepared by the Department of Corrections. This applies only to the initial term of incarceration and to no other term of sentence or probation. It is further our understanding that the prosecution has no objection to proceeding by way of no contest plea and has stipulated to the offer of proof prepared by the defense in order that the defendant may minimize exposure to potential civil liability.
Thank you, sir. Mr. Webb, is that your full and complete understanding of the plea agreement as well?
It is, Your Honor. It's, and I'll let Mr. Moore correct me if I'm misunderstanding this, but he and Mr. Ambrositis have agreed to scoring on certain OBs, 10 points for OB 3, 10 points for OB 17, and 15 points for OB 18, equaling 35 points for the offense variables. But I don't think there is an agreement as to what the guidelines are.
That is correct, Your Honor. In an earlier draft of the offer of proof, it inadvertently stated that the parties had agreed to a particular guideline range. That was incorrect. I then amended the offer of proof to reflect the offense variables as stipulated by the parties. No statement has been made as to prior record variables, nor have we stipulated to a particular guideline range. Those facts are set forth in the offer of proof, but there was some at least a potential for confusion, so I appreciate Mr. Webb bringing that up.
Thank you, sir. With those clarifications, Mr. Webb, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
And do you concur, Mr. Moore?
Yes, Your Honor.
Now, Mr. Horowitz, did you hear what the assistant prosecutor, your lawyer, said the plea agreement is?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty or to get you to plead no contest?
No, Your Honor.
So, for example, has anyone promised you that if you plead no contest to count one, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or threatened your family to get you to plead guilty, to get you to plead no contest?
No, Your Honor.
Is it your own personal choice to plead no contest? And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still want to plead no contest to count one?
Yes, Your Honor.
Very well, the court has had the opportunity to read through the offer of proof that the defense attorney prepared in this case, and that the parties want the court to consider. And the court finds that the offer of proof establishes date being on or about December 8th of 2017, venue being Grant Township in Clare County, Michigan, identification of the defendant, as well as the elements of operating a motor vehicle while intoxicated, causing serious injury. Do you agree, Mr. Moore?
Yes, Your
And do you agree as well, Mr. Webb?
Yes, Your Honor.
As the court also finds the reason given for the no contest plea being minimization of potential civil liability is an appropriate reason, especially since the people concur in a no contest plea. Do you so concur, Mr. Webb?
Yes, Your Honor.
And has the court complied with the court rule and the taking of the no contest plea to count one, Mr. Moore?
Yes, Your Honor.
And Mr. Webb?
You have, Your Honor.
Very well, in this case, the court has not agreed upon a possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate, has been understandingly, knowingly, and voluntarily made. The plea of no contest to count one is accepted and will be entered on the records of the court. H. M. Brubaker, would you prefer that I schedule sentencing in 4 weeks' time on July 19th? Or to schedule the sentencing in August?
August, please, Your Honor. Thank you for asking.
Thank you, ma'am. Would August 2nd give you enough time?
Yes, sir.
Very well, then we'll schedule sentencing for 9 a.m. on Monday, August 2nd, 2021. Is there any issue as to bond, Mr. Webb?
No, Your Honor.
Ask that it be continued here.
Thank you, Mr. Ward. Bond will be continued. The case will be adjourned to date and time set for sentencing. Mr. Horowitz, when you come back on that day, you could be put in prison for up to 5 years, or you could be put in the county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay some court-ordered money that will probably add up to about $2,300. Plus, there might well be restitution involved, which might be a far amount. But in any event, you now have another 6 weeks or so to take legal steps to raise that money and have it available to you at the time of sentence. Now, I'm going to turn matters over to Agent Brubaker from the probation department. She might have some additional instructions to give to you. Agent Brubaker.
Your Honor, I can meet with them just outside after this hearing. Thank you.
Thank you, ma'am. Thank you, Mr. Horowitz. We'll see you back here on August 2nd. Thank you, sir. Is that the last of our cases?
I'm sorry.
I was jumping and I thought that was the last of your cases, but Mary reminds me Sarah Poole is available to be sentenced today.
Well, she might be. I don't know if she's actually available. She's certainly scheduled. I know that she's been making good efforts to get in. Okay, she's here now. I received a text during the last hearing.
Thank you, sir.
We're ready. Sure.
Calling the case of People versus Sarah Elizabeth Poole, file 21-6596-FH, with counsel identified for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Please, the court's got more.
And Miss, are you Sarah Elizabeth Poole?
Ms. Poole? No?
Yes, I can hear you now.
Could you tell us your name, Miss?
Sarah Elizabeth Poole.
Would you raise, well, Ms. Poole, previously back on May 17 of 2021, you appeared in court in this file, and at that time you pled guilty to the 10-year felony crime known as possession of methamphetamine. You appeared here today to be sentenced, and the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report and a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 6 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Miss?
Yes, Your Honor.
Mr. Moore, have you gone over both of these reports with your client?
Yes, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
Oh, yeah.
And on behalf of the people, Mr. Webb, I pose the same series of questions to you.
Your Honor, I've reviewed the reports, have no additions or corrections to make to them, and the guidelines are correct in score.
And Mr. Moore, if I ask you this, I apologize, but do you have any challenges to the scoring of the prior record variables or the offense variables or the calculation as to the applicable sentencing guideline range as being 0 to 6 months?
No objection.
Thank you, sir. Ms. Poole, is there anything, ma'am, you want to say on your own behalf before the court passes sentence?
No, Your Honor.
On behalf of your client, Mr. Moore?
Your Honor, my client, she's a single mother. This is her first significant brush with the law. And as the report writer indicated, the defense investigation report, she is a candidate for 7411 status. So for those reasons, we would ask the court to adopt recommendations and try to find a great scope for agreement in this matter.
Thank you, sir. And on behalf of the people, Mr. Webb?
Your Honor, I had noted those same items that she's 23, single mother. She has no record that I found. I also believe she should be a good candidate for 7411. However, the report indicates she's employed at the Lakeside Bar and Grill as a waitress. That would seem to conflict with number one, paragraph number one of her probation recommendations. So I don't know how the court wants to deal with it.
Thank you, sir. Very well, ma'am. In order to punish you for what you've done and to deter you and others from committing crimes in the future, so to give you the chance to rehabilitate yourself, Ms. Poole, it's the sentence of the court. You'll be placed on probation for a period of 1 year. Now, in addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which include but are not limited to: you must not use or possess any alcohol or controlled substance or drug paraphernalia, submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must seek and maintain full-time employment and or be enrolled in the full-time education program. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not possess any weapons or copies of weapons. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. And you must submit to your person and property without the need of a search warrant if the probation agent has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. If the probation agent believes you are conducting yourself in a manner inconsistent with the public good, he has the legal right to arrest you. Similarly, if he has reason to believe you have violated your probation, he has the legal right to arrest you. You must not have any contact with Derek Strobel, either directly or indirectly. You must pay $68 in state costs and a crime victims assessment of $130, court costs of $500, and a fine of $500. The court-appointed attorney fees of
We estimate $210.
court-appointed attorney fees of $210. How much of that $1,400 or so do you have available today to apply towards your court-ordered monies, ma'am?
I have all of it right now to pay all of that.
Then all of that money must be paid in full by 3 p.m. today. And all of it, of course, must be paid by the time you get off of probation, but it's specifically an order of the court and the term of your probation and a condition of your sentence. You must pay the entire amount by 3 p.m. today. I'm not going to put you in jail today, ma'am. The final decision I have to make is whether to grant you this special status under Michigan compiled law 333.7411. If I don't do that, two bad things happen. One is a terrible thing, which is you wind up convicted of a 10-year felony, you could wind up in the state's prison. In addition, you would go through your life being a convicted felon. You would lose some of your constitutional rights for a period of time. You would lose your right to vote for a period of time. And you would lose your Second Amendment right to keep and bear arms essentially forever as a practical matter. I'm going to grant you the 7411 status and give you a chance to keep this felony conviction off of your record. I agree with your lawyer that you're a good candidate for this special probation, and I agree with the probation agent and the prosecutor. But I will tell you this, that the only thing in this whole report that gave me pause, made me think perhaps you won't be able to successfully complete the probation, was that even though you were in possession of methamphetamine at the time you committed this crime, that you contend, I've never used any controlled substances except a little bit of marijuana here and there. Now that's conceivable. It's conceivable that that's the truth, but it's not plausible. And unless you get a handle on the extent of your substance abuse proclivities, it's going to be very hard for you to not use controlled substances in the future. But those are matters you're going to have to deal with. That will be the sentence of the court, and because I granted the 7411 status, there was no need to advise you of any appellate rights because they don't get attached because the court has not imposed a final sentence. Agent Brubaker, do you have any additional instructions you wanted to give to Ms. Poole?
Yes, thank you, Your Honor. Ms. Poole, this is Agent Brubaker with the Probation Department. I need you to call me tomorrow morning at 9 a.m. Are you ready for my phone number?
Yes, I'm ready.
989-423-9411.
Okay.
Thank you.
Thank you.
Thank you, ma'am. Is that the last of your cases, Mr. Moore?
Oh, I know you were trying to rush me off the stage about half an hour ago. Yes, finally, yes.
Thank you, sir. Calling the case of People versus Clayton Robert Reed. File numbers 21-6618-FH and 21-6060-FC. Would counsel identify for the record, please?
Good morning, Your Honor.
Mark Webb, in file 21-6618 FH on behalf of the people.
Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people in 21-6650-FC.
Good morning, Your Honor. Gerald White representing Mr. Reed on both charges.
Today is the date and time scheduled for a pretrial conference. Mr. White, are we proceeding by way of a pretrial conference or by way of guilty pleas?
By way of a pretrial conference, Your Honor.
Very well. Do you want the cases scheduled for a jury trial in each case?
No, Your Honor, I think it's premature. I have been in contact with the prosecutor's office and have been provided a pretrial summary in both files. One was received last week after I had a discussion with the prosecutor's office from on one case, on the case that's involved with the possession of meth. That'd be the 6618 file. And I just received this morning an updated pretrial summary on the 6650 FC file. I've had an opportunity to talk with Mr. Reed in the jail this morning. I had the pretrial summary. It was my fault that I did not receive it. It was posted to me on last Thursday, but I just received it this morning. So we have not had a chance to go over it in any kind of detail. So I'm asking the court to set this matter over for a status conference if the court would do that, so that I have an opportunity to talk about the new pretrial summary that I received from the prosecutor's office on the file 6650 FC.
All right, thank you, sir. I'll schedule each one of the cases for a status conference occur at 9:20 a.m. on Tuesday, July 6th, 2021. And the bond status in each case will be continued. The cases are adjourned to the date and time.
Would the court take consideration into a bond modification at the request of my client? He asked me to do that this morning, and I'm asking the court to take consideration to that. He currently is on a bond on all his files of $192,500 from what he indicates to me.
What is it he wants, Mr. White? Does he want me to cut the bond all the way in half down to 96,000 something in total in all of the cases?
That would be an improvement, yes, Your Honor.
All right, the court will cut the bond in half in these matters, and the case will proceed to the status conference on July 6th.
Very well, Your Honor. Thank you very much.
Thank you, sir.
Thank you.
Thank you for being here, sir.
All right, Gerald. Am I good to go?
Yes, sir, you are.
Thank you, guys.
You're welcome, Mr. Reed. Calling the cases of People versus Frank Mitchell Provence Jr., file 19-6268-FH and 21-6580-FH. Would counsel identify for the record, please?
Gerald White, representing Mr. Provence, Your Honor, on both files.
Your Honor, Mark Webb on behalf of the people.
And Agent Caitlin Brubaker also appears on behalf of the Clare County Circuit Court Probation Department and Michigan Department of Corrections. Mr. White, today is the date and time scheduled for a status conference on the 2021 case and the probation violation case from 2019 as well. How does your client want to proceed in those two matters, sir?
Well, Your Honor, I would ask the court to continue with a status conference, and here's the reason. I received a call last week from Lisa Ashford, the coordinator for the recovery court, and she inquired as to whether or not Mr. Provence would be amenable to recovery court. And I says, I'm not quite sure if he would be, but I think he would be. And she indicated that she would attempt to make some contacts with the court as well as the prosecutor's office to see if that would be a feasible resolution to this case. In other words, the recovery court. But I have not heard back from Ms. Ashley as to whether or not she's been successful in talking with the other parties. So I have to court to set this matter over for another status conference until I can resolve that issue.
Your Honor, if I may.
Sure, Mr. Webb.
Mr. White, there's been no referral from our office regarding recovery court. I don't know why Ms. Ashley's jumping the gun in this case. As far as I know today, there's no offer of recovery court.
I understand that, but that's what I want to make sure that I cover all my bases as to whether or not Mr. Vermont's may indeed be a candidate for recovery court. I realize that is not a fact that's at this point in time.
All right, we'll schedule the two cases for a status conference at 9:20 a.m. on Monday, July 19, 2021. The bond status in each case will be continued, and the cases will be adjourned to that date and time.
Did the court indicate July 19?
Yes, sir.
Okay. Thank you.
Hopefully that will give, I have no idea if, perhaps you're drilling in a dry hole, perhaps recovery court is not any kind of feasible option here, but at least a month from now, everyone should be on the same page about what the viable options are and what they are not. Thank you, sir, and those two cases will be adjourned to the date and time indicated.
Thank you very much, Your Honor.
Thank you, sir. Calling the case of People versus Jacob Richard Vanden Bosch, file 20-6509-FH. Would counsel identify for the record, please?
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Good morning, Your Honor. Gerald White representing Mr. Vanden Bosch.
Mr. Vanden Bosch, would you raise your right hand and be sworn, sir?
Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Could you tell us your name, sir?
Jacob Richard Vanden Bosch.
Thank you, Mr. Vanden Bosch. Today is the date and time scheduled for a status conference in this matter. How did you want to proceed regarding that status conference, Mr. White?
Your Honor, if it pleases the court, I've had an opportunity also in this case to consult with the prosecutor's office last week, and I received a new trial summary changing the offer from the prosecutor's office slightly, but I would ask the court to give me an opportunity to discuss this in detail with Mr. Vanden Bosch. The offer looks acceptable, but I would like to have more time with Mr. Vanden Bosch to make sure he understands all the ramifications of the offer that's being made. And so I would ask the court to set this matter over to a new date.
All right. Very well, then the court will schedule this case for entry of a plea or a status conference to occur at 9:20 a.m. on Monday, July 19, 2021. The bond status will be continued and the case will adjourn to the date and time indicated. Thank you for being here, Mr. Vanden Bosch.
If I may, can I go into a breakout room?
I have no idea if your lawyer has any time at this moment to speak to you or not. Do you have any position in that regard, Mr. White?
No, that's acceptable, Your Honor. And once I've finished with the breakout room with Mr. Vanden Bosch, I'll just leave the meeting.
Okay. Then the clerk of the court will place the two of you into a breakout room.
Thank you, Your Honor, for your help.
Thank you, sir. Sure.
Could the person whose number ends in 773 please unmute and identify yourself? Hi, could the person whose number ends in 773 please unmute your microphone and identify yourself?
Hillary Doyle.
Thank you. I am going to put you back in the waiting room until it is time for your hearing.
Okay, thank you.
Thank you. Could the person whose number ends in 993 please identify yourself?
Samantha Oxer.
Thank you. I'm going to put you back in the waiting room until it is time for your hearing. Hi, can you unmute your microphone and please identify yourself? I need you to unmute your microphone. And your name, please? Hello?
Jerry, I think she's talking to you. Hello.
Can you identify yourself, please?
He has a hard time hearing.
I need your name. I need his name.
I think he needs your name. Gerald McKinstry.
What was the last name? I'm sorry.
McKinstry.
Okay, and what case are you here for?
Hillary Doyle.
Thank you. Okay, I'm going to put you back in the waiting room until it is time for the hearing.
Okay, thank you.
Thank you. Are they reading?
Hello.
They're just waiting Mr. Shook in now.
All right, thank you. If possible, I'll need a very brief breakout room, please.
Okay.
So.
Calling the case of People versus Carrie Ann Smedley, file 21-6622-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Tara Hovey appearing on behalf of Carrie Smedley, who I see is present in the courtroom via Zoom.
Does anyone appear on behalf of the people?
Is Mark Webb there?
What's that?
Is Assistant Prosecutor Webb available? Or is he not there?
He's not physically present in the courtroom, Ms. Schwartz.
I will appear on his behalf in this particular case.
Thank you, Ms. Schwartz. Chief Assistant Prosecuting Attorney Alicia Schwartz appears on behalf of the people. Today is the date and time scheduled for a pretrial conference in this matter. Ms. Hovey, does your client want to proceed by way of a pretrial conference or by way of a plea?
At this point, Your Honor, by way of a pretrial conference, I do anticipate this could result in a plea in the near future, but at this point, we're requesting a pretrial.
All right. Would you like the matter scheduled for a jury trial?
Yes, Your Honor.
Thank you, ma'am. And do you think it would take a couple of days or more or less? Or?
2 days, Your Honor.
And I would ask that any pretrial motions be filed within 28 days from today. And or within 28 days of filing of the transcript of the preliminary examination, whichever is later. Is there anything else you wanted to address, Ms. Hovey?
No, Your Honor.
Very well, then the case will proceed to trial. The bond status will be continued. Thank you for being here, Ms. Schwartz. Thank you for being here, Ms. Hovey, and for being here as well, Ms. Smedley. Ms. Smedley, make sure you stay in touch with your lawyer. Thank you.
Okay.
Ms.
Thank you, Your Honor.
Thank you, ma'am. Calling the case of People versus Jeffrey Lee Miracle, file 21-6624-FH. Would counsel identify for the record, please? Jeffrey Lee Miracle.
On behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Miracle.
Today is the date and time scheduled for an arraignment in this matter. How did you want to proceed in that regard, Mr. Rowe?
Your Honor, there's been a plea bargain offered and Mr. Miracle would like to accept that plea bargain.
Thank you, sir. Mr. Miracle, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You need to unmute. Can you unmute your computer?
Can you hear me now?
Yes.
Yes, sir. First, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Could you tell us your name?
Jeffrey Lee Miracle.
Mr. Miracle, do you understand, sir, that according to count one of the information that you are charged with possession of methamphetamine?
Yes, Your Honor.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison, and the minimum sentence is discretionary with the court. Do you understand those things, sir?
Yes, Your Honor.
There are three possible pleas that you may make count one, possession of methamphetamine, and they are as follows. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one, possession of methamphetamine?
Yes, Your Honor.
Then answering to count one, possession of methamphetamine, what is your plea?
I'm going to plead guilty, Your Honor.
And sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, Your Honor.
The court also informs you that if your plea of guilty to count one is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, sir?
Yes, Your Honor, I do.
Do you understand that by pleading guilty to count one, that means you'll be giving up each and every one of these rights?
Yes, Your Honor.
Now, sir, I'm going to ask your lawyer and the prosecuting attorney to tell us what the plea agreement is, and I want you to listen to both of them very carefully. And on behalf of the people, what is the plea offer?
Your Honor, the plea agreement is that the defendant will plead guilty to possession of methamphetamine. In exchange for that, we will be dismissing the remaining charges at sentencing. There is also, and the second or subsequent notice at sentencing. There is a recommendation that he receive 75 days in jail with credit for 75 days served, plus a term of probation to be determined by the court. Restitution is also to be determined at a later date, which is part of this agreement as well.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
Your Honor, I'd only know that I understand the sentencing recommendation to be a bridge killer agreement.
And is that correct, Ms. Schwartz?
Yes, Your Honor.
Thank you, ma'am. Mr. Miracle, did you hear what Chief Assistant Prosecuting Attorney Schwartz and your lawyer, Mr. Rowe, said the plea agreement is?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count one?
No, Your Honor.
So for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or your family to get you to plead guilty?
No, Your Honor.
Is it your own personal choice to plead guilty? And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you, sir?
No, I don't, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty to count one, possession of methamphetamine?
Yes, Your Honor.
And sir, drawing your attention back to on or about September 13 of 2020, were you in Hayes Township in Clare County, Michigan?
Yes, Your Honor.
On that day and at that location, did you have some methamphetamine in your possession?
Yes, Your Honor, I did.
Did you know that the substance you possessed at that time was methamphetamine at the time you possessed it?
Yes, Your Honor.
Did you have any legal right or justification or mitigation to permit you to possess this methamphetamine?
No, Your Honor, I didn't.
But you went ahead and possessed it anyway, is that true?
Yes, sir.
Very well, in this case, are you satisfied, Mr. Rowe, that there's a sufficient factual basis to accept the plea of guilty to count one?
I am, Your Honor.
Do you agree, Ms. Schwartz?
Yes, Your Honor.
And Mr. Rowe, has the court complied with the court rule and the taking of the plea?
It has, Your Honor.
Do you agree, Ms. Schwartz?
I do.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing will occur on Monday, August 2nd at
10:20 a.m., Your Honor.
10:20 a.m. Thank you, Mr. Rowe. At 10:20 a.m. The bond status is continued. The case is adjourned to the date and time indicated by Mr. Horowitz. When you come back on that day, you could go to prison for up to 10 years, or you could be put in the county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay some court-ordered money that will add up to at least $2,200 or $2,300. You now have another 6 weeks or so to take legal steps to raise that money and have it available to you when you come back here on August 2nd. The probation agent might have some additional instructions to give to you. Agent Brubaker.
Thank you, Your Honor. Mr. Miracle, what is a mailing address for you?
It is 320 North Cedar Street, Lot 13, Sanford, Michigan, 48657,
And a phone number?
989-630-7587.
Mr. Miracle, you'll be getting a packet in the mail from my office. Please fill it out completely, and an agent will be in contact with you.
Okay.
Thank you, Your Honor.
Thank you, sir. And thank you, Agent Brubaker. We'll be in recess on that matter then. Calling the case of People versus Samantha Ann Oxer, file 21-6571-FH. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Oxier.
Ms. Oxier, would you please raise your right hand to be sworn, Mass?
Yes.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name?
Samantha Oxer.
And Ms. Oxer, today is the date and time scheduled for a pretrial conference in this matter. Mr. Rowe, how does your client want to proceed? By way of pretrial conference or by way of plea?
Your Honor, if you'd allow me to talk with Ms. Oxier for a moment in breakout room, I've been having some trouble getting a hold of her, Your Honor.
Sure. Ms. Oxer, I'll give you the chance to talk things over with your lawyer, and then when you return in a few minutes, we will decide, you will decide what it is you want to do in this case. Thank you, ma'am.
Okay. All righty.
Thank you, miss.
You should be able to.
It's Mr. Schmidt, which is Mr. Duke.
Yes. Okay. Thank you very much. Calling the case of People versus William Shook, file 21-6663-FH. Would counsel identify for the record, please?
Attorney Alicia Schwartz, appearing on behalf of the people.
Thank you, Your Honor. Todd Dieter, appearing on behalf of Mr. Shook.
Mr. Shook, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name, sir?
William Sheldon Shook.
Thank you, sir. You may be seated if you'd like. Mr. Dietrich, today is the date and time scheduled for an arraignment in this matter. How does your client want to proceed regarding that arraignment?
Your Honor, it's my understanding that Mr. Shook has been made an offer to plead guilty with an agreement at the end of the guidelines that he could be sentenced to a tether, and he would like to proceed with that.
So he would be pleading guilty as charged to aggravated stalking. Is that correct?
That is correct, Your Honor.
Mr. Shook, do you understand, sir, that according to count 1, you are charged with aggravated stalking?
Yes, Your Honor.
Now, aggravated stalking is a felony and it carries a maximum penalty of 5 years in prison and/or a fine of up to $10,000. And the minimum sentence is discretionary with the court. Do you understand those things?
Yes, I do, Your Honor.
Now, with regard to count 1, aggravated stalking, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1, aggravated stalking?
Yes, I do, Your Honor.
In answering to count 1, aggravated stalking, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, I do, Your Honor.
The court also informs you that if your plea of guilty to count 1, aggravated stalking is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. You understand all of these rights?
I do, Your Honor.
And do you understand, sir, that by pleading guilty to count 1, aggravated stalking, that means you'll be giving up each and every one of those rights?
I do.
Now, I'm going to ask your lawyer, Mr. Dietrich, and the Chief Assistant Prosecuting Attorney, Ms. Schwartz, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Ms. Schwartz, what is the plea agreement in this case?
The agreement in this case is that the defendant will plead guilty as charged, and in lieu of an incarceration, we will be agreeing to allow him to have GPS tether That would obviously be needing to be in place prior to his release from incarceration. And that concludes the offer.
Mr. Dietrich, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Shook, did you hear what your lawyer and the chief assistant prosecutor, Ms. Schwartz, said the plea agreement is?
I did, Your Honor.
Did you understand the plea agreement?
Yes, I did, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count 1 aggravated stalking?
No, Your Honor.
For example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or your family to get you to plead guilty?
No, Your Honor.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty to count 1 aggravated stalking?
Yes, Your Honor.
And sir, drawing your attention back to May 13 of 2021, were you in Hayes Township in Clare County, Michigan?
No, I was not, Your Honor.
Okay, where were you?
I was at, in Reading Township, Your Honor, at my residence.
And that is here in Clare County, is that correct?
Yes.
And on or about that day, did you engage in a course of conduct that caused Stacy Laney Cooper to feel frightened and harassed and intimidated and molested and terrorized and threatened?
Yes, Your Honor.
And would that course of conduct that you engaged in have caused a reasonable person to feel frightened, harassed, intimidated, molested, terrorized, and threatened?
Yes, Your Honor.
And that's exactly how it made Stacy Laney Cooper feel, is that correct?
Yes, Your Honor.
What were some of the things that you did on that day in this course of conduct?
There was several unanswered text messages and a couple of unanswered phone calls.
Okay, and these were unanswered text messages that you sent to Stacy Laney Cooper and unanswered telephone messages that you left for her?
Yes.
Is that correct?
That's correct.
Are you satisfied there's a sufficient factual basis to accept the plea of guilty to count 1, Mr. Rowe?
Your Honor, I'm sorry, this is Todd Dietrich. It's my
I'm
case.
sorry, Mr. Dietrich. I apologize, Todd. Are you
No.
satisfied there's a sufficient factual basis, sir?
Well, Your Honor, I think that there was a no contact order that was in place that has to be put on the record in order to make it the aggravated, and that it was a violation.
You probably are correct. And do you wish to inquire of your client in that regard, Mr. Dietrich?
Yes, Your Honor. Thank you. Mr. Shook, at the time that you made these text messages that went unanswered, as well as the telephone calls that went unanswered, there was a court order in place that prohibited you from making contact with, is it Miss Quaker?
Yes.
So there was a court order in place that prohibited you from doing that contact. Is that correct?
That is correct.
And despite that court order, you still attempted that contact. Is that correct?
That is correct.
All right, thank you.
Thank you, sir. And Mr. Shook, this court order that prohibited the conduct, was that a condition of pretrial release or bond or bail?
Yes, it was.
Are you satisfied, Mr. Dietrich, that there's a sufficient factual basis to accept the plea of guilty to count one aggravated stalking?
Yes, Your Honor.
Do you agree, Ms. Schwartz? Mr. Dietrich, has the court complied with the court rule in the taking of this plea?
It has, Your Honor. And when the court allows me to, I have a comment to make when the court's ready.
Sure. But before we do you agree that the court has complied with the court rule in the taking of the plea, Ms. Schwartz?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one aggravated stalking is accepted and ordered entered on the records of the court. Sentencing will occur at 9:40 a.m. on Monday, August 2nd, 2020. The bond status is continued. The case is adjourned to the date and time set for sentencing. But there was a comment or a request you wanted to make, Mr. Dietrich.
Yes, Your Honor. Thank you. Number one of two, I wanted to remind the court that he's currently scheduled for sentencing on August 2nd, 2021 on a separate matter. So the court has made this the same date, and that's what I was going to suggest. But number two, thank you. Number two, the reason why it got adjourned from June 7th was because there's a listing of a felony conviction, and Mr. Shook-Leasy does not have a felony conviction. And as of this date, I've been unable to get confirmation from either the prosecutor or the courts in terms of whether or not it was a conviction for a felony previously when we were looking at his guideline scoring. And so I just wanted to refresh the memory of the probation department and as well as the prosecutor's office that we're still trying to sort that out prior to August 2nd.
Thank you, sir.
Thank you, Your Honor.
Thank you very much. Very well, the case will be adjourned to the date and time indicated. Do you have any additional instructions you wanted to give to Mr. Shook with regard to the sentencing agent?
No, Your Honor, he's already completed PSI. Somebody will be in contact with you, Mr. Shook, at the jail, my department. Thank you.
Thank you.
Thank you, ma'am, and thank you, sir. That will be in recess on that matter.
Thank you, Your Honor.
Hey, Todd, can I speak with you?
They'll put me in a breakout room, you can.
Just something real brief.
Calling the case of People versus Melissa Ann Ofulu, file 21-6013-FH. Would counsel identify for the record, please?
Chief Assistant Prosecuting Attorney Elisa Schwartz, appearing on behalf of the people.
Morning, Your Honor. Joseph Duso appearing on behalf of
You're gonna put me in a breakout room.
Melissa Ofulu, is appearing via Zoom.
Good morning, Ms. Ofulu, and good morning, Mr. Russo and Ms. Schwartz. Today is the date and time scheduled for a pretrial conference in this matter. Are we proceeding by way of pretrial conference or by way of guilty plea, Mr. Russo?
believe we will be entering a plea in this matter.
Okay, and to what count or counts would that be a plea?
It's my understanding the offer is Ms. Ophelu will be pleading guilty to both counts with a delay of sentence with repayment of restitution as part of successful delay. If the delay is successfully completed, both counts 1 and 2 would be dismissed. And I believe there's a recommendation for no initial incarceration. Ms. Schwartz can correct me if I have that incorrect.
Thank you, Ms. Schwartz. Ms. Ophelu, would you please raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
Melissa Ann Ophelu.
You may be seated if you'd like, Ms. Ophelu. Ms.
Thank you.
Ophelu, do you understand that according to count 1, you are charged with the felony crime commonly as welfare fraud over $500?
Yes, sir.
Now, that crime is a felony and it carries a maximum penalty of 4 years in prison and or a fine of up to $5,000, and the minimum sentence is discretionary with the court. Do you understand those things, ma'am?
Yes, sir.
Do you also understand that according to count 2, you are charged with the felony crime commonly known as welfare fraud by failure to inform in an amount of $500 or more? Do you understand that, ma'am?
Yes, sir.
Now, that crime is a felony. It carries a maximum penalty of up to 4 years in prison and or a fine of up to $5,000. You understand those things?
Yes, sir.
Now, with regard to both count 1 and also with regard to count 2, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1 and the 3 possible pleas you may make to count 2, Ms. Ophelu?
Yes, sir.
Then answering to count 1, what is your plea?
I'm going to plead guilty, Your Honor.
And answering to count 2, what is your plea?
I'm also going to plead guilty to count 2, Your Honor.
And is that what your plea is, both to count 1 and count 2?
Yes, sir.
Now, ma'am, do you understand that no one can make any promises for me about what your sentences will be?
Yes, sir.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a hearing of any kind. I'm sorry, you won't have a trial of any kind. If your pleas of guilty are accepted, you will not have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to testify, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Ms. Ophelu?
Yes, Your Honor.
Do you understand that by pleading guilty, that means you'll be giving up each and every one of those rights?
Yes, Your Honor.
Now, I'm going to ask the Chief Assistant Prosecuting Attorney, Ms. Schwartz, and your lawyer, Mr. Dusso, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Ms. Schwartz, what is the plea agreement?
The agreement is that the defendant will plead guilty to both counts as charged. There will be a delay of sentence with restitution to be paid in full as a part of the successful delay of sentence. There is a particular agreement of no initial incarceration, and restitution is estimated at this point in time at $3,253 owing to MDHHS.
And if the defendant successfully completes the delayed sentence probation, will each of these charges be dismissed?
Yes, Your Honor.
And alternatively, if the defendant fails to successfully complete the delayed sentence probation, the convictions would be entered on her record and the court would proceed to sentence on the 2 4-year felonies. Is that correct, Ms. Schwartz?
Yes, Your Honor.
Mr. Dusso, is that your full and complete understanding of the plea agreement as well?
Yes, Your Honor.
Ms. Ophelu, did you hear what the Chief Assistant Prosecuting Attorney, Ms. Schwartz, and what your lawyer, Mr. Dusso, said the plea agreement is, ma'am?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, Your Honor.
So for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or threatened your family to get you to plead guilty, ma'am?
No, Your Honor.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still want to plead guilty to count 1 and count 2?
Yes, Your Honor.
Then, ma'am, drawing your attention back to on or about December 31st of 2017, were you in Sheridan Township in Clare County, Michigan?
Yes, sir.
On that day and at that location, were you receiving assistance or relief in the form of welfare?
Yes, Your Honor.
And did you obtain that assistance or relief by means of making a willful false statement or willful false representation to the authorities on or about December 31, 2017?
I'm not sure how to answer that, Your Honor.
I don't know how to answer it either, ma'am, but you're the one who came into court, raised your right hand to be sworn, swore to tell the truth, the whole truth, and nothing but the truth, so help you God, and just got through telling me a moment ago that you in fact are guilty as charged of both count 1 and count 2. Now, it's not too late. You have every right in the world to go to trial on these 2 4-year felonies, but what was your answer, or what is your answer to the question the court just posed to you, Ms. Ofalu?
I believe it would be willful.
Okay, you knew you were doing something wrong. Is that true, ma'am?
Yes, sir.
You knew you were misrepresenting some of the facts to the government. Is that correct, ma'am?
Yes, sir.
And if the true facts had been presented by you to the government, you would not have received the welfare payments that you did receive back in and around December 2017. Is that
yes,
also
sir.
true? And by making these false representations and false statements, you did in fact receive these welfare payments. Is that correct, ma'am?
Yes, sir.
And that was the whole point of you lying to start with and making these false statements and representations. Is that correct, miss?
I'm sorry, I did not hear you, sir.
That was the whole point. That was your whole motive in making these false statements, correct? Was to get money that you were not entitled, correct?
Yes, sir.
Yeah, if I may, I believe it was her willful intent to failure to keep her information current and inform the department. So it was an omission rather than an actual overt statement made.
Thank you, Ms. Schwartz. Were you indicating that the defendant is obligated to make truthful statements about her income and that in fact she refrained from revealing all of her sources of income?
Yes, Your Honor.
Is that correct, Ms. Ofalu?
Yes, Your Honor.
Now, during this same time, back on or about December 31 of 2017, with regard to count 2,
My feed stopped.
well, first, what's that, ma'am?
My feed stopped. Everything went blank. I got you back now.
We've all been able to hear you. Have you been able to hear everything that's been going on, Ms. Ofalu?
Yes, until just now.
And now can you hear everything once again?
Yes, sir.
All right. We were accepting a plea of guilty to count 1, welfare fraud in an amount of $500 or more. And you had indicated along the way that you provided willful false statements or representations to the government in an attempt to get the government to pay you welfare that you were otherwise not entitled to. Is that all true, miss?
Yes, Your Honor.
And did you in fact receive payments from the government?
Yes, Your Honor.
And did those payments total an amount of more than $500?
Yes, Your Honor.
And then in addition, with regard to count 2, is it true, miss, that you were required as a condition of receiving these welfare payments to provide updated reports to the government of it concerning any change in circumstances?
Yes, Your Honor.
Circumstances? And did your circumstances change, ma'am?
They did, Your Honor.
And did they improve?
They did.
And as a result of that improvement in your financial circumstances, did you have a legal obligation back in December of 2017 to make a truthful report to the government, letting them know that your financial circumstances had improved?
Yes, Your Honor.
And did you fail to do that?
Yes, Your Honor.
And did you in fact, and as a result of that failure, did you continue to receive some welfare payments that you otherwise would not have received?
Yes, Your Honor.
And the additional welfare payments that you received that you otherwise would not have received, was that more than a total amount of $500?
Yes, Your Honor.
Mr. Dusso, are you satisfied that there is a sufficient factual basis to accept the defendant's pleas of guilty to count 1 and count 2?
Yes, Your Honor.
Do you agree, Ms. Schwartz?
Yes, Your Honor.
Mr. Dusso, has the court complied with the court rule in the taking of the pleas of guilty to count 1 and count 2?
Yes, Your Honor.
Do you agree, Ms. Schwartz?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or pleas or the possible sentences with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the pleas are accurate and have been understandingly, knowingly, and voluntarily made. The pleas of guilty to count 1 and count 2 are accepted and ordered entered on the records of the court. Sentencing will occur on Monday, August 2nd, 2021 at 10:40 a.m. The case will be adjourned to that date and time, and the bond status will be continued. But when you come back here on that day with cola food, you could be sent to prison, or you could be put in the county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay some court-ordered money that will add up to probably a little more than $2,000, plus restitution on top of that. So you now have another 6 weeks to raise that money or a substantial part of that money and have it available to you when you come back here to be sentenced on August 2nd. Before we adjourn, Ms. Olafu, the probation agent Brubaker might have some additional instructions to give to you.
Okay, Your Honor.
Ms. Opalu, what is your mailing address?
8701 East Clarabella Road, Clare, Michigan, 48617.
And your phone number?
989-418-1956.
You'll be getting a packet in the mail from my office. Please fill it out accurately and completely, and somebody else will be in contact with you as well. Thank you.
Thank you.
Thank you, Mrs. Ruffalo, and thank you, Ms. Brubaker. We'll be in recess on that matter.
Is that sentencing in person, Your Honor?
I would prefer that it be in person. And let's do the sentencing in person.
Your Honor, if I may, I do
Yes, ma'am.
that the defendant does need to be fingerprinted. Is there a way that we could get an order signed for her to be fingerprinted?
I thought she was fingerprinted already.
Thank you, Ms. Schwartz. Thank you, Mr. Dusso. I will sign an order to that effect. If it's already been accomplished, then there won't be a need to be double fingerprinted, but otherwise, between now and the August 2nd, the order will be that the defendant must be fingerprinted.
Thank you.
Thank you, Ms. Schwartz. We are, I believe, done, Mr. Russo.
Thank you, Your Honor.
On your case.
Thank you.
Thank you, sir. Austin, are you ready to proceed on the Auxier case?
Yes, I am, Your Honor.
Recalling the case of People versus Samantha Ann Auxier, file 21-6571-FH. Would counsel identify for the record?
Morning, Your Honor, Mark Webb on behalf of the people.
Your Honor, Austin Arrow, appearing on behalf of Ms. Auxier.
Ms. Auxier, would you raise your right hand to be sworn, ma'am?
Yes, sir.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name?
Samantha Auxier.
Ms. Auxier, you may be seated if you'd like. Today is the date and time scheduled for a pretrial conference in this matter. Does your client want to proceed by a pretrial conference or by way of entering a plea, Mr. Rowe?
Your Honor, at this date, Ms. Auxier wants to proceed by a pretrial conference. She is still willing to consider plea bargain offers, but declines the current one.
All right, then we'll schedule the case for a jury trial. That's what you would like, correct, Mr. Rowe?
Yes, Your Honor.
And will 2 days suffice for the trial?
I believe it would.
Very well, then the case will proceed to jury trial or other disposition. Ms. Auxier, make sure you stay in touch with your lawyer, Mr. Rowe.
Okay, like who, Austin Rowe? Because I'm firing him and hiring a new lawyer.
Miss, you are not firing anybody. Mr. Rowe is your attorney. The only person who can quote fire, unquote, your lawyer is the court. Now, if you get off your duff and you go out and you hire a lawyer and that lawyer indicates he or she wants to file a substitution of attorneys, he or she can do that. Otherwise, unless and until that happens, Mr. Rowe is still your lawyer. And regardless, Mr. Rowe is still your lawyer until further order of the court. Nothing has been brought before the court as of today to change that. If in fact in the future, ma'am, you decide in your infinite wisdom that you want to hire a different lawyer, feel free to notify the court. Thank you for being here. The case will proceed to trial or other disposition. Make sure you stay in touch with your lawyer. Make sure you show up on time every time when you're ordered to in court, and make sure you follow all the terms and conditions of the bond. We'll be in touch.
Absolutely. All righty.
Thank you, ma'am. Sure. Where is it? What did you say? Okay. Calling the case of People versus Corey Caleb Isbell, file 19-6236-FH. Would counsel, I for the record, please.
Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Ms. Van Nendrup, you need to unmute.
I apologize. Good morning, Your Honor. Brandy Vandenbroek appearing on behalf of the defendant Corey Caleb Isbell.
Good morning, Ms. Vandenbroek. Good morning, Ms. Schwartz. Good morning, Mr. Isbell. Mr. Isbell, if you would come forward, sir. You may have a seat at the table if you'd like. Are you Corey Caleb Isbell? Yes, Your Honor. Previously, Mr. Isbell, you appeared in court back on May 17 of 2021 in this case, and at that time, you pled no contest to count 2, assault with a dangerous weapon, and to count 4, domestic violence. You appear here today to be sentenced as to each of those 2 convictions. Count 2, assault with a dangerous weapon, is a felony, and it carries a maximum penalty of 4 years in the state's prison, and the minimum sentence would be discretionary with the court. Count 4, domestic violence, is a misdemeanor, and it carries a maximum penalty of 93 days in the county jail and a maximum sentence of $500, a maximum fine of $500, and the minimum sentence for each one of these 2 convictions is discretionary with the court. You understand those things, Mr. Isbell? Yes, Your Honor. Now, the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared a pre-sentence investigation report and a sentencing information report. And with regard to the felony conviction, the departments calculate your applicable sentencing guideline range, at least thus far, they calculate the guideline range to be 0 to 17 months. Although pursuant to People versus Lockridge, those guidelines now are discretionary rather than mandatory. And with regard to the misdemeanor conviction, there are no sentencing guidelines. Do you understand those things, Mr. Isbell?
Yes, Your Honor.
Thank you, sir. Ms. Vandenbroek, have you gone over these reports with your client?
Yes, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor. I would just say that I believe that Mr. Isbell could function very well outside of a jail sentence as long as he continues his mental health treatment and remains employed.
Thank you, ma'am. Do you have any challenges to the scoring of the offense variables or the prior record variables or the calculation as to the applicable sentencing guideline range with regard to the felony as being 0 to 17 months?
No, Your Honor.
And on behalf of the people, Ms. Schwartz, I pose the same series of questions to you.
We have no additions or corrections to the pre-sentence investigation report. It appears to be scored appropriately. We ask you to follow the recommendation in the plea agreement.
And Mr. Isbell, is there anything, sir, you want to say on your own behalf before the court passes sentence? And on behalf of your client, Ms. Vandenbroek?
Just that I think that the whole process for Mr. Isbell has been enlightening. I think he benefited greatly from his time in mental health treatment. And based on conversations that I've had with him and with opposing counsel, that course of action, we do believe will strongly benefit him into the future as long as he continues, because he now has access to the help that he needs.
Thank you, ma'am. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. And on behalf of the people, Ms. Schwartz?
Your Honor, I do ask that you follow the recommendation of the Michigan Department of Corrections in this particular case and the plea agreement. I encourage Mr. Isbell to continue his mental health treatment and other treatment as recommended, even on those really good days when he feels like everything is going well. The importance is being stable and consistent and sustained with his treatment to address the issues that he needs to address, and that may be a lifelong process for him. So that's all I would like to note for the court and Mr. Isbell is wishing his best on that.
Thank you. Very well, Mr. Isbell, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. You'll be placed on what is commonly called delayed sentence probation for a period of up to 1 year. Now, in addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well. And those terms include, but are not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program or mental health treatment program or alternatives to violence treatment program to which the probation agent refers you, and you must give up any accountability right you have in such program so that the court may monitor your progress. You must seek full-time employment, and or you must be enrolled in a full-time education program. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must not possess any weapons or copies of weapons. You must submit to a search of your person and property without the need of a search warrant if the probation agent has reason to believe you have violated your probation. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even reason to believe that you are conducting yourself in a manner inconsistent with the public good. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not have any contact whatsoever with the Ellison job or be within 500 feet of her residence, school, or place of employment. You must pay $115 in state costs and a crime victims assessment of $130, a court cost of $500, and a fine of $500. How much of that $1,250 or so can you pay today, sir? $100. All right, then you must pay $100 by today, by 3 p.m. today. And then you must pay an additional $100 each and every month to be paid by 12 noon on the first day of each month, with the first payment due by 12 noon on August 1st, and each additional payment due by 12 noon on the first day of each month after that, until paid in full. But all of that money must be paid by the time you get off of probation. We'll schedule you for final sentencing for each one of these two matters, the misdemeanor and the felony, on the first day, on the first motion day in May of 2022 at 11 a.m. And in the meantime, sir, that will be the sentence of the court. Business delayed sentence process. But before you leave here today, Agent Brubaker might have some additional instructions to give to you. Or do you have any instructions you'd like to give at this time?
I'll be right after the hearing. Thank you.
Thank you, Agent Brubaker. Thank you, Mr. Isbell. And make sure you abide by this delayed sentence probation, sir. I don't think you had any earlier or prior felony conviction. And through the good offices of your lawyer and the prosecuting attorney, you're being given a chance to keep the felony conviction off your record. And I'm sure that you have the capacity to follow this probation, but I just hope you have the initiative and the motivation to do it. So good luck to you, sir. Thank you, Ms. Vandenberg. Thank you, Ms. Schwartz. And thank you for being here, Mr. Isbell.
Thank you very much, Your Honor.
Thank you.
You're welcome again.
Ton.
Could the person whose number
Right here.
ends in 866 please identify yourself?
Ryan Beebe.
Thank you, Mr. Beebe. We will be to your case in just one moment. I'm going to put you back in the waiting room.
Okay.
Good afternoon. Can you identify yourself for the court, please? The person with the Galaxy S21. Can you identify yourself for the court, please?
Calling the case of People versus Hillary Renee Doyle, file 20-6375-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Austin R. Rowe appearing on behalf of Ms. Doyle.
And Miss, are you Hillary Renee Doyle?
Yes, sir. Hillary Renee Doyle.
And today is the date and time scheduled for a status conference in this case. Does your client wish to proceed by way of entry of a plea, Mr. Rowe?
Your Honor, before I get to the answer to that question, can I inquire of Mr. Webb whether he's got lab reports on that?
Austin, I did get your, if I may, Your Honor.
Sure.
I did get your email Friday, didn't get a chance to respond. I don't see any of my files. I had Beeger send that to the lab back in March, I think, February or March. And I just sent an email to the office about a half hour ago to see if we had a lab report. So at this point, I don't, and I don't know.
Your Honor, I'd have to inquire of Ms. Doyle because I've been having trouble getting a hold of her too. But last time I spoke with her, there was some interest in the plea bargain offer, but she wanted to at least an opportunity to look at the lab reports to see if there was indeed what was claimed to have been in her possession.
Well, at the risk of being facetious, she wants to make sure she didn't get stiffed by her dealer. That in fact, what she did have was diazepam, as the people claim. In any event, you don't want to proceed by way of plea today. Is that correct, Mr. Rowe?
I believe so. Is that true, Ms. Doyle?
Yes.
All right, we'll schedule the case for entry of a plea on the morning of Monday, July 19th. And what is your normal time, Mr. Rowe?
10:20 a.m.
At 10:20 a.m., the bond status will be continued. The case is adjourned at the date and time indicated. Between now and then, ma'am, Ms. Doyle, I want you to stay in touch with your lawyer, and we'll see you back here on July 19th.
Your Honor,
Yeah, because he has contacted me not one time, and
well, then I guess you better get a hold of him, hadn't you, miss?
okay.
Make
Yes.
sure you stay in touch with him. Thank you for being here. We'll be in recess.
Also, Miss Doyle, put the cigarette out. You're in court.
Okay.
Thank you, sir.
I
Calling the case of People versus Bethany Nicole Thompson, file 20-6501-FC. Would counsel identify for the record, please?
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Thompson.
Ms. Thompson was scheduled to appear in court at 10:21 today. It's now 2¼ hours past that time. It's 12:35 p.m. by the court's clock. Ms. Thompson is not physically present, nor is she present via Zoom. However, in fairness to Ms. Thompson, I believe she is lodged in the Isabella County Jail. And earlier today, the Isabella County authorities did have her available for a pretrial conference, but they are no longer available. We will adjourn today's pretrial conference until Monday, July 19th at 10:20 a.m. And the bond status will be continued. It's now 12:36 p.m. Thank you, Mr. Rowe.
Thank you, Your Honor.
Do you have other matters set for today, sir?
I believe I have two more, Your Honor.
Thank you.
I believe I have a Stephanie Johnson, and I believe I saw earlier on the jail was Jason Jones.
Jason Jones.
Arraignment today.
Thank you, sir.
Jones is incarcerated.
Thank you, sir. I didn't think this. Yeah. Thank you for speaking. Thank you. Calling the case of People versus Jason Allen Jones, file 21-6631-FH. Would counsel identify for the record, please?
Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Jones.
Today is the date and time scheduled for an arraignment in this case. How does your client want to proceed in that regard? Mr. Rowe?
Your Honor, at this time, Mr. Jones waives the reading and pleads not guilty.
Very well, pleas of not guilty will be entered on behalf of Mr. Jones as to all counts in this matter. The case will proceed to a pretrial conference or other disposition. The bond status is continued. Thank you for being here, Mr. Jones.
Your Honor, if it would please the court, he would like to address bond.
Okay, what is bond currently set at, Mr. Rowe?
Your Honor, his bond is currently set at $90,000, cash surety 10%. That was set back on his arraignment of district court on April 13th, 2021. He has not been able to raise bond. Mr. Jones has lived in Clare County for 15 years. He has a mother, father, and grandmother and child that lives here. My understanding is that he tells me he's never been convicted or has never missed a court hearing. And he's asking the court to amend bond to $20,000, cash surety 10%.
First, on behalf of the people, Ms. Schwartz, even though you might oppose the motion, do you have any objection to the court hearing the motion today?
No, Your Honor.
Very well then. Second, do you oppose the motion?
People do, Your Honor. There is no change in circumstances from when the bond was initially set. I think that the reasons for the bond being placed are appropriate in light of the circumstances and the charged offense. I ask that it remain the same.
Thank you, ma'am. It does appear to the court that the bond is appropriately set. The motion for reduction or change in bond is denied. The bond will continue at the current amount. We'll see you back here, sir, for the pretrial conference. Thank you for being here. Thank you.
Good afternoon. Can you identify yourself for the court, please? Mr. Rowe, is that your client?
No, Your ma'am.
Okay, thank you.
Stephanie Johnson would be about middle age, I believe, if not younger.
Could the person with the Galaxy S21 please identify yourself for the court?
Calling the case of People versus Stephanie Renee Johnston, file 21-6609-FH with counsel identified for the record, please.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Johnston.
Ms. Johnston was ordered to be here today for a pretrial conference 2 hours and 20 minutes ago at 10:20 a.m. It's now 12:41 p.m. by the court's clock. The defense attorney appeared in a timely fashion, as did the prosecuting attorney. Ms. Johnston has failed to appear. Do you know why that is, Mr. Rowe?
Your Honor, that's what puzzles me today. I sent out a notice to her on May 18th by U.S. mail and also by email, telling her time and date, giving her the invites to appear in court on this time and date. I had tried to contact her earlier this morning. According to caller ID, she did try to call back once, And I've tried to call her back twice after that without success. So I don't know what's going on, Your Honor. I'm kind of playing phone tag, I believe, with her today.
Thank you, sir. Very well, then the court will order Ms. Johnston to appear on Monday, July 19 at 10:20 a.m. to show cause why she should not be held in criminal contempt of court for her alleged failure to appear here today and why her bond should not be revoked and forfeited. The record should reflect it's 12:42 p.m. by the court's clock. Ms. Johnston still has failed to appear.
Your Honor, Grace asked, are you ordering her to appear in person or just appear by Zoom?
Thank you, Mr. Webb. I will order that Ms. Johnston appear in person at the scheduled time on July 19th. Is that the last of your cases, Mr. Rowe?
Yes, it is. Thank you, Your Honor.
Thank you, sir.
See you later this afternoon on the 2:30 case, Your Honor.
Thank you, Mr. Rowe. We'll see you then.
All right, bye.
Thank you.
Mr. Beebe, can you hear the court?
Yes.
Thank you.
Regarding the case of People versus Nicholas Lloyd, file 21-6664-FH. In that matter, the defendant has filed a waiver of arraignment and the court has signed that waiver. So the case will proceed to a pretrial conference. Calling the case of People versus Ryan Stephen Beebe, file 21-6625-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk on behalf of Ryan Beebe.
Mr. Beebe, would you raise your right hand to be sworn, sir?
Do you solemnly swear
Yes.
or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name?
Ryan Beebe.
Thank you, Mr. Beebe. Today is the date and time scheduled for a pretrial conference in this case. Do you want to proceed by way of pretrial conference or by way of plea, Ms. Tomczyk?
Well, Your Honor, I did receive an updated offer from the prosecutor, but I haven't had a chance to discuss that with my client. So my thought would be is based on the late hour, let's just do the pretrial conference and set this matter for a status conference in a month.
Very well. Do you want the case scheduled for a jury trial?
At this point, yes, Your Honor.
Do you think it will take more than 2 days or not?
I don't believe so.
All right. Do you concur in those things, Mr. Webb?
Yes, Your Honor.
Was there a pretrial or preliminary examination held in this case, Ms. Tomczyk?
No, Your Honor.
Very well, then I would ask that any pretrial motions be filed within 28 days of today's date. And the case will proceed to trial or other disposition. Thank you for being here, Mr. But make sure you stay in touch with your lawyer. Make sure you continue to follow the conditions.
Okay.
Thank you, sir. We'll be in recess on your case. Ms. Tomczyk, the clerk of the court is indicating that she does not have any other of your clients who have appeared either in person here in the courtroom or via Zoom. How would you like to proceed?
Your Honor, I have Mr. Lane here in my office, but I have not heard back from the prosecutor on potentially resolving this case. So I'm not sure where we want to go with that. I could set Mr. Lane up to appear, but I'd kind of like to figure out what we're doing with the case first.
Okay, thank you, ma'am. Do you have any other clients there at your office?
Not that I'm aware of.
Well, I guess perhaps then we can go through some of the other defendants who were ordered to appear here today. Calling the case of People versus Nicholas J. Lloyd, file 21-6664-FH, with counsel identified for the record, please.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Mr. Lloyd. Your Honor, you just signed a waiver of arraignment on that case, I believe.
Thank you, ma'am. Very well. Apparently, a waiver of arraignment has been signed. If so, the court will sign that waiver of arraignment and entry of plea. If not, we'll reschedule the arraignment. Calling the case of, in the event a waiver has been filed, the case will proceed with pretrial conference. Calling the case of People versus Tracy Ryan Miller, file 21-6562-FH, with counsel identified for the record, please.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk on behalf of Mr. Miller. It's my understanding that the court ordered him to be there in person.
Okay.
So if we could page the hallway, maybe?
I'm sorry, go ahead, ma'am.
If we could page the hallway, as the court ordered Mr. Miller to be there in person.
Thank you, ma'am. The court security officer is going to page 4, Mr. Miller.
Ryan Miller.
Your Honor, is he paging Ryan Miller?
Yes, he is, ma'am, which would be the middle name of your client. Just on the off chance that someone is so brain dead, they're out in the hallway saying, I'm not Ryan Miller, I'm Tracy Ryan Miller. Would you please call the name, Tracy Ryan Miller?
Tracy Ryan Miller. No response, Your Honor.
Thank you, sir. Very well, the record should reflect this case was scheduled for a status conference almost 3 hours ago at 10 a.m. It's now 12:50 p.m. by the court's clock. Mr. Miller has failed to appear. The court security officer has paged him in the hallway, and I believe actually that back on May 17, the court ordered that the defendant must appear here in person today because at that time he allegedly failed to appear back on May 17 as well. The defendant has failed to appear here today. The court will revoke and forfeit his bond and issue a bench warrant for his arrest to be brought before the court to show cause why he should not be held in criminal contempt of court for his failure to appear here today. Bond on the bench warrant is set in the amount of $4,000 cash only, to be posted only in the defendant's own name. The record should reflect it's now 12:52 p.m. by the court's clock, and Mr. Miller still has failed to appear. Calling the cases of People versus Eric Philip Lugo, file numbers 17-5735-FH and 18-5804-FH and 21-6545-FH. Would counsel identify the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk on behalf of Eric Lugo. Your Honor, Mr. Lugo has never missed court before. He's always kept in good contact with my office. This seems a bit odd. I do know he has court in district court scheduled here in about 7 minutes or so. So I would ask that the court maybe set this matter for a show cause hearing and not forfeit his bond.
Very well, the court will schedule these matters in all three cases for a show cause on Monday, July 19, 2021 at 9:20, at 10 a.m. For the defendant to appear and show cause why his bond should not be forfeited and why he should not be held in criminal contempt of court for his alleged failure to appear here today. The record should reflect the defendant was ordered to be here at 10 a.m. It's now almost 3 hours past that time. It's 12:54 p.m. by the court's clock. He has failed to appear. The defense attorney appeared in a timely manner, as did the assistant prosecuting attorney, Mr. Webb. So thank you all for being here, and we'll be adjourned as to that matter. And calling the cases of People versus Joshua L. William Carlton, file numbers 18-5964-FH and 20-6308-FH and 21-6565-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk on behalf of Mr. Carlton. Your Honor, again, this is Mr. Carlton's first failure to appear. He keeps in good contact with my office, so I'm unaware as to why he's not here, and would ask that the court set this matter for a show cause hearing.
Very well, the court will schedule this matter for a show cause hearing at 10 a.m. on Monday, July 19, 2021. But the defendant must appear in person at that time to show cause why he should not be held in criminal contempt of court for his alleged failure to appear here today in these three files. The record should indicate the defendant was ordered to be here at 10:03 a.m. Today. It's now almost 3 hours past that time. It's 12:50 p.m. by the court's clock. The defendant has failed to appear. Thank you, Ms. Tomczyk. And then calling the cases of People versus Timothy Lynn Lane, file numbers 19-6106-FH and 21-6558-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk appearing on behalf of Mr. Lane. I have asked my staff to give, yep, there's Mr. Lane now.
Mr. Lane, would you raise your right hand to be sworn, sir?
Mr. Lane, your microphone does need to be unmuted.
Okay, how's that?
There you go, thank you. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name, sir?
Timothy Lane.
Mr. Lane, you appear here today in file 2019-6106-FH for a status conference regarding your probation violation matter, and in file 2021-6558-FH. You also appear here today for a felony, on a new felony matter for a status conference. How does your client want to proceed in those two matters, Ms. Tomchuk?
Well, Your Honor, we have been trying to work out a kind of a global resolution between the probation violation and the new case. I had got in contact with Mr. Webb regarding his and the probation's standpoint on a counteroffer that I had proposed to them.
And do you know the status of that matter, Mr. Webb?
I do not, Your Honor.
Well, do you do you just want to go ahead and have a hearing on the probation violation matters, Ms. Tomchuk? Would you like to proceed?
Well, Your Honor, like I said, we have tried to.
I apologize for interrupting Ms. Tomchuk.
If you could give Mr. Baker and I a couple minutes, and then maybe we'll have something for Ms. Tomchuk.
Did you hear that, Ms. Tomchuk?
I did, Your Honor.
Thank you. Then we will take a brief recess.
And then I can drink it daily.
All rise. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. Calling the cases of people is Timothy Lynn Lane. File numbers 19-6106-FH and 21-6558-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people in 21-658-FH. And Ms. Brubaker's here on the PV file.
Thank you. And appearing on behalf of the defendant in each of these two cases,
Aaron Tomchuk appearing on behalf of Mr. Lane.
Mr. Lane, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help God?
Yes, ma'am.
Could you tell us your name, sir?
Lynn Lane.
Thank you, sir. And how are we proceeding in these two matters, Ms. Tomchuk, by way of plea or in some other fashion?
We are proceeding by way of plea, Your Honor. If I could set the factual basis when that's time is ready.
Okay. We'll start then with the 2021 file, 21-6558-FH. Is that to be a plea to count one, Ms. Tomczyk?
That is count one with the second or subsequent offense notice being dismissed.
Okay, and so, Mr. Webb, are you asking to amend the information on the record by striking the second or subsequent offense notice?
Yes, Your Honor.
Any objection, Ms. Tomczyk?
No, Your Honor.
Very well, the court will amend the information on the record by striking the second or subsequent offense notice information. Mr. Lane, do you understand, sir, that in file 21-6558-FH, that according to count one as amended here on the record, that you are charged with the crime of possession of methamphetamine?
Yes, sir.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison and or a fine of up to $15,000, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes, sir.
With regard to count one, there are three possible pleas that you may make, and they are as follows. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas that you may make to count one as amended here on the record? Then answering to count one, possession of methamphetamine, what is your plea?
Guilty,
What is your plea, sir?
yeah. Are you gonna say, yes, I had it?
Mr.
Yep.
Lane,
All right.
Mr. Lane, you're pleading
Is-
guilty, correct?
Am I supposed to say anything right? I'm supposed to say guilty?
Yes.
Okay.
All right, so what is your plea to count one, sir? Could you repeat that?
Guilty?
Thank you, sir. Now, do you understand, there probably is a plea agreement of some sort, but do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your plea of guilty to count one is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial, and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, sir?
Yes, sir.
And do you understand, Mr. Lane, that by pleading guilty, that means you'll be giving up each and every one of those rights?
Yes, sir.
Now, I'm going to ask your lawyer and the prosecuting attorney to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding the defendant will plead guilty to possession of methamphetamine, and in exchange for that, I will dismiss the second or subsequent drug offender notice, recommend a sentence of no initial incarceration and a term of probation, and that would run concurrent with the probation violation plea sentence.
Thank you, sir. Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
No, Your Honor, I asked the prosecuting attorney whether that was going to be a Briggs-Killebrew agreement to no initial incarceration, and he stated yes.
That's fine.
All right. With that clarification, is that your full and complete understanding of the plea agreement, Ms. Tomczyk?
It is, Your Honor.
Now, Mr. Lane, did you hear what your lawyer and the assistant prosecuting attorney said the plea agreement is?
Yes, sir.
Did you understand the plea agreement?
Plead guilty and I just get more probation time instead of jail?
All right, I'm not quizzing you, sir. I'm not asking you to tell me what the plea agreement is. I'm just asking you, do you understand the plea agreement? And do you understand it, sir?
Yes, sir.
Now, with that in mind, do you still want to plead guilty to count one?
Yes, sir.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, sir.
So, for example, has anyone promised you that if you plead guilty, that this court then will be lenient or light on you in any way?
No, sir.
Has anyone threatened you or your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
What was
No,
that,
sir.
sir? Do you understand everything that the court has told you?
Yes, sir.
Now, in light of everything that the court has told you, do you still want to plead guilty to count one?
Yes, sir.
Then, sir, drawing your attention back to on or about August 3rd of 2020, were you in Hatton Township in Clare County, Michigan?
Yes, sir.
And on that day and at that location, did you have some methamphetamine in your possession?
Yes, sir.
Now, at the point in time when you had that methamphetamine in your possession, did you know that it was methamphetamine?
Yes, sir.
Did you have any legal right or justification or mitigation to permit you to possess the methamphetamine at that time?
No, sir.
But you went ahead and possessed it anyway, correct? Is that correct, sir?
Yes, yes.
Thank you, sir. Now, Ms. Tomczyk, are you satisfied that there's a sufficient factual basis to accept the plea of guilty to count one as amended here on the record?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes.
Ms. Tomczyk, has the court complied with the court rule in the taking of this plea?
It has, Your Honor.
And do you agree, Mr. Webb?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor or the defendant or defense attorney or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing will occur on Monday, August 2nd at 10 a.m. The bond status is continued and the case is adjourned to the date and time set for sentencing. Do you have any additional instructions you want to give at this time to Mr. Lane regarding the sentencing on the new felony conviction?
Thank you, Your Honor. Mr. Lane, is your address still 6918 South Ruby Drive in Harrison?
Yes, it is.
That's a mailing address as well, correct? Okay, and a phone number for you?
99-339-7936.
Okay, an agent from our office will be in touch with you regarding a PSI interview. Thank you. I'll say.
Thank you, sir. And thank you, Ms. Brubaker. Turning to file 19-6106-FH. Mr. Lane, would you raise your right hand to be sworn, sir?
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Could you repeat that, sir?
Yes, ma'am. Yes, I do.
Thank you, sir. And are we proceeding regarding the probation violation charges from August 3rd of 2020 or from a later date?
August 3rd, Your Honor, 2020.
Thank you. And would that be with regard to count one and count two, or just one of those counts?
One of those counts, would you like me to place the plea sentence on the record, Your Honor? Please, rectification, sorry.
Sure. Well, before we do that, which count would it be?
Count two,
Thank you.
plead guilty.
Thank you.
Yep.
Mr. Lane, do you understand that in this 2019 file, that you currently are on probation to this court? For
Yes, sir.
10 years, and that you're on probation also for the 10-year felony crime of possession of methamphetamine?
Yes, sir.
Now, as a consequence, if you plead guilty to violating your probation, or if you're found guilty of violating your probation, then the maximum penalty the court could impose in the 2019 file would be 10 years in prison, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes, sir.
Now, sir, do you understand that according to count two of the probation violation charge from August 3rd of 2020, that it is alleged you did violate condition 2.4 of your probation order, which required that you must not use or possess any controlled substances. And specifically, it's alleged in count 2 that back on or about August 3rd of 2020, you possessed methamphetamine. Do you understand count 2?
Yes, sir.
Now, with regard to count 2, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 2?
Yes, sir.
Then answering to count 2, what is your plea, sir?
Guilty?
You are pleading guilty, is that correct, sir?
Yes, what my lawyer told me I'm supposed to do.
Well, regardless of what your lawyer told you to do or not do, are you pleading guilty to count 2?
Yes, sir.
Thank you, sir. Very well. Are you, Mr. Lane, do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your plea of guilty to count 2 is accepted, then that means you won't have a hearing of any kind in this file, and you therefore would be giving up each and every one of the following rights in this 2019 probation violation file. The right to have a contested probation revocation hearing, the right to be represented by a lawyer, and the right to have a court-appointed lawyer if you're financially unable to hire a lawyer, the right to appear at that hearing and to present evidence and to cross-examine witnesses, the right to require that the probation agent or the prosecutor prove by a preponderance of the evidence that you violated your probation as alleged, the right to remain silent and to not have your silence used against you, but on the other hand, you also do have the right to testify at the hearing, and if you choose to do so, your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Lane?
Yes, sir.
And do you understand that by pleading guilty to count 2, that means you'll be giving up each and every one of those rights?
Yes, sir.
Now, sir, I'm going to ask your lawyer and the probation agent and the assistant prosecutor to tell us what the plea agreement is, and I want you to listen to them very carefully. Ms. Tomczyk, what is the plea agreement in this file?
Your Honor, in exchange for Mr. Lane's plea of guilty to count 2, count 1 would be dismissed. There is also a sentence agreement to time served, but an agreement that Mr. Lane would lose his 7411 status.
Is that your full and complete understanding of the plea agreement, Ms. Brubaker?
Yes, and added that he would continue on probation, which will run concurrent with his current felony that he just budgeted.
Thank you, ma'am. With that clarification, is that your full and complete understanding of the plea agreement, Ms. Tomczyk?
Yes, Your Honor.
And Mr. Webb?
Yes, Your Honor.
Now, Mr. Lane, did you hear what the prosecuting attorney, the probation agent, and your lawyer all said the plea agreement is, sir?
Yes, yes, I did.
Did you understand the plea agreement?
Yes,
And do you agree with that plea agreement?
yes, sir.
Now, sir, has anyone promised you anything beyond what is in the plea agreement to get you to plead guilty?
No, sir.
So for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Now, do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, I understand.
And in light of everything that the court has told you, do you still wish to plead guilty, sir?
Yes, sir.
Drawing your attention back to December 10 of 2019, did I sentence you in this 2019 file on that day, sir?
I believe so.
I sentenced you back then. You're not sure of the exact date. Is that true?
I can't quite remember. I don't, but a while ago, I did what I was supposed to do.
All right. Is it true, sir, that back in December of 2019, I sentenced you in this case and I put you on probation as part of the sentence? Is that true?
Yes, sir.
And is it true that when I put you on probation, I made a condition of your probation that you were not allowed to possess any controlled substances?
Yes.
Now, you knew that was part of your sentence when I first sentenced you back in December of 2019, correct?
Yes, sir.
And in the year and a half since then, I never changed that condition of probation, did I?
No, sir.
And you knew that as well, didn't you, sir?
Yes, sir.
Drawing your attention back to August 3rd of 2020, on or about that day, did you have some methamphetamine in your possession, sir?
Yes, sir.
And did you know that the substance you possessed on that day was methamphetamine at the time you possessed it?
Yes, sir.
And did you know that you were violating your probation by possessing the methamphetamine?
Yes, sir.
Did you have any legal right or justification or mitigation to permit you to possess the methamphetamine at that time?
No, sir.
Are you satisfied, Ms. Tomchek, that there's a sufficient factual basis to accept the defendant's plea of guilty to count 2 of the probation violation charge, ma'am?
Yes, Your Honor.
Do you agree, Mr. Webb
Yes, Your Honor.
and Ms. Brubaker?
Yes, sir.
Has the court complied with the court rule in the taking of the plea, Ms. Tomchek?
It has, Your Honor.
Do you agree, Mr. Webb
Yes, Your Honor.
and Ms. Tomchek?
Yes, Your Honor.
I'm sorry, ma'am. I said Ms. Tomchek. I meant to say, do you agree as well, Ms. Brubaker?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate, is bindingly, knowingly and voluntarily made the plea of guilty to count 2 is accepted and ordered entered on the records of the court. Sentencing will occur at 10 a.m. on Monday, August 2nd, 2021 as well. The bond status is continued adjourned to the date and time set for sentencing. Ms. Brubaker, do you have any additional instructions to give to Mr. Lane?
No, Your Honor.
Thank you. Thank you, Mr. Lane. Make sure you continue to abide by all the terms of your probation. And we'll see you back here on August 2nd. Thank you, sir. Thank you, Ms. Tomczyk. Ms. Tomczyk, is that the last of your cases?
It is, Your Honor.
Thank you, ma'am. We'll be in recess then.
All right. 55th Circuit Court is in session. The Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. Calling the case of Douglas Brink versus Alex Vanek, file 19-900435-CH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Joe Brown on behalf of the plaintiff.
Good afternoon, Your Honor. Dan Lobello on behalf of the Bannocks.
Today was the date and time scheduled for a status conference in this matter. The last time we were in court a month ago, the court adjourned the trial without a date. And the attorneys had indicated they would be meeting with expert witnesses. And I scheduled a status conference for today. What is the status of the case from your point of view, Mr. Brown?
Your Honor, I've got to take a little responsibility. I didn't get anything from the other side until about a week ago. And frankly, it was some information from the expert witness. I haven't had the ability, or I haven't connected yet with their expert witness who they said I could discuss it with. From my client's standpoint, it's not something that's readily acceptable, and I have questions over it. I had intended to get these things all sorted out prior to today, but it just didn't happen. I apologize that I haven't had the ability to get things done that I had hoped.
It's quite all right, Mr. Brown.
Well, I can say definitively where we are on whether or not that's going to be something that's going to resolve the case or not. While I'm not enthused, I just don't know enough yet because I haven't been able to work all the way through it. So.
All right, so from your point of view, how would you like to move forward, Mr. Brown?
I'd like to set another status conference in the near future, not a month out, like maybe 2 weeks, something like that. I think would be appropriate, just to see, because I'm not. I don't know. I mean, what we've gotten at least gives the party something to discuss, and I just haven't had the ability to get through it and meet with my client and talk with their expert and go back to defendant's counsel and see where we're at. So I'd hate to say this is complete no and let's reschedule trial because I just don't have confidence that that's ultimately what's going to happen. I think that I'm optimistic, maybe foolishly so, that there's a chance that we could still do something.
All right. And how would you like to move forward from here, Mr. Carbajal?
Dan Lobello here on behalf of Mr. Carbajal, Your Honor.
I'm sorry.
That's okay.
Thank you, sir. Dan Lobello.
So we've consulted with our expert. We've kind of had an idea as to what the parties' goals were, with what they needed to do with the respective properties. As Mr. Brown indicated, he did create a diagram that shows a way to manage the water flow among both parcels, which I think is going to alleviate the drainage issue. Mr. Brown has stated that he hasn't had a chance to review that with his client yet, which is fine by us, but we've given him, our expert's contact information so that we can go back and forth and try some new ideas. I'm not oppose the idea of setting a new status conference date. I'll leave that to the court's discretion in terms of when that might be. But I think that there's a fair opportunity that this matter might be resolved. Mr. Brown might disagree, but we can see what happens from there. We're optimistic, Your Honor.
All right, well, thank you, sir. I could schedule the matter for a status conference on Monday, July 19, which would be almost a month out. I could also schedule it for Tuesday, July 6th. And maybe that would be productive, although I don't know with the holiday in there really. Would you prefer the 6th or the 19th, Mr. Brown?
We prefer the 6th if it's going to be by Zoom, which I would appreciate.
Is that acceptable to you, Mr. Lavelle?
We could do the 6th, Your Honor. That's fine.
All right, why don't we schedule a status conference then for 2 o'clock on Tuesday, July 6th? And is there anything else you wanted to address today, Mr. Brown
No, sir.
or Mr. Lavelle?
Nothing further from our end, Your Honor.
All right, well, thank you all for being here then, and we'll see you back here on July 6th then.
Thank you.
Thank you very much, Your Honor.
Thank you, sir. Calling the case of Terrence J. Brighton versus Walter Caskey Jr. Would counsel identify for the record, please?
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Caskey.
Thank you. Does any prosecutor appear in this case? The record should indicate no response. Mr. Caskey, would you please come forward, sir? And would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. You may be seated if you'd like. Could you tell us your name?
Walter James Caskey.
You may be seated, sir. And is Terrence John Brighton also present?
Yes, sir.
Sir, if you would come up to the other table and raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name, sir?
Terrence Brighton.
You may be seated if you'd like, Mr. Brighton. Has there been a resolution in this matter, Mr. Rowe?
No, Your Honor.
All right, well, what brings us into court is that back in September of 2020, the petitioner, Terrence Brighton, filed a petition for a personal protection order. Then on September 2nd, 2023, the court issued an ex parte personal protection order against Walter Caskey Jr., prohibiting him from doing certain things with regard to, specifically with regard to the petitioner, Terrence Brighton. Then after that occurred, according to proof of service in the file, Deputy Aaron Miller of the Clare County Sheriff Office served a copy of the personal protection order, or PPO, on Walter Caskey on September 9. Then on September 23rd, 2023, the respondent, Walter Caskey, filed a motion to terminate the personal protection order. The court heard that motion on October 7, 2020, and at the end of the motion, the court issued an order denying the motion to terminate the PPO, and it instead left the personal protection order in effect for the original duration of the personal protection order. That was about 8 months ago on October 7th, 2020. Then after that occurred on May 4 of 2021, the petitioner Terrence Brighton filed a motion for an order for Mr. Caskey to be brought to court to show cause why he should not be held in criminal contempt of court for allegedly violating the terms of the personal protection order. Mr. Caskey was arraigned on that motion on May 17, at which time the motion hearing was adjourned to a later date because Mr. Caskey had asked to have be appointed to represent him. And the court on that day, May 17, appointed Attorney Austin Rowe to represent respondent Walter Caskey. Ultimately, the hearing on the motion to hold Mr. Caskey in criminal contempt of court was scheduled to be heard here today. And at 2 p.m., 2:30 p.m. And we appear here today on that motion. Mr. Brighton, do you still want Mr. Caskey to be held in criminal contempt of court?
Yes, Your Honor.
All right. Now, the court issued the personal protection order September of last year. Apparently, a copy of it was served on Mr. Caskey after that. You filed a motion to have Mr. Caskey held in criminal contempt of court, and in your motion, you wrote that on January 4 of 2021, Walter Caskey plowed snow in the road. You called, was that, what do you mean by that?
He pushed it over from his side of the, from his yard road driveway area and pushed it over into my side of the shoulder of the road and stuff. Like, yeah, I got a police report, and he was ticketed for that. There's a police report right here where they had come out to the house. I got a copy of that.
And you wrote, you called the police, they talked with him. Then you wrote, he continues to shine lights January 7, 2021 from 7:30 to 8:45 p.m. 7:30 p.m. to 8:45 p.m. on January 7. He was shining lights. January 19 from 6 p.m. to 10 p.m. January 20th from 7:40 p.m. all night. January 21, 9 p.m. to all night. You wrote, kid pulled in drive, lights came on. What do you mean by that, sir?
My daughters and friends would come over to the house, and as soon as they pulled in the driveway, he'd flip his lights all on, big spotlights, shining them until they left. I have notes in here for you to read, Your Honor. I got pictures of where the lights was real bright. Then he went just before we come to court here the last time, before you ordered the lawyer, that changed them down to the old style, or yellow instead of bright white. And that anybody come to my driveway or come to my house, the lights come on, and they stayed on until half hour, 45 minutes after he left. They left.
Thank you, sir.
Even the school bus driver has, letter in there.
You say January 27th, 28th, 29th, and 31st. Apparently, on those nights, he had the lights on. Is that correct?
Yes, sir.
And you said January 30th, when shoveling the roof off. What do you mean by that, sir?
I was shoveling my roof off. We had that real heavy snow and all that stuff. And my wife, I told her to leave the door open just in case I fell off because there was ice on the roof. If I slipped and fell, that I could holler for her. He decided he had to open his windows and crank the music up and make all kinds of noise. If I had fell off the roof, my wife would have never heard me. You know, I couldn't call for help because he had the music going so loud.
And do you believe that somehow violated the personal protection order?
Well, I think that ain't right. You know, if I got hurt, how would I call for help when all you could hear was music?
Light on and off all month. March 23rd, 2021, found large amount of motor oil around my mailbox. Do you know where that motor oil came from, sir?
No, I found the footprints where it's coupled around when they was poured, where they had poured it, and it came, the footprints was tennis shoes, and they come from his driveway and back to his driveway. Yeah, I had it on, I had videoed it, I had lost my phone, it had the video on.
Okay. Well, what part of the PPO do you think these things violate?
Well, Your Honor, I'd like you to read these letters, and the main thing is with this lawnmower going over to the neighbors where it all started at one time. You know, he's being too close to me, and I fear that, you know, I'm not safe to be out in my yard or sit on my porch and that, because I call it, he gets drunk or high, whatever, you know, he gets tanked up like that, and then he comes out and does all kinds of stuff just to aggravate me and the neighbors and stuff like that. If you read some of these letters here from the neighbors, even the neighbor who lives next to me, is sitting back there and wrote you a letter. Will tell you, he just comes out, we call it drunk courage or high courage, or whatever you want to call it, sir. And feel that when he took that lawnmower and went over to the neighbors, I don't know if he's got a gun or not. He says he don't have guns in his house, but we've heard the neighbors that come over to my house, hey, did you hear them gunshots over your way? It sounded like it come from his house over there, you know? And I said, yeah, I heard shots.
Your Honor, I object to this. This is hearsay evidence that Mr. Brighton is introducing at this moment.
Was sustained. You indicate also, sir, in your motion, you wrote, survey was gone. Is that the survey stakes?
Yes, it's a survey stake. Yeah. The neighbor was putting a shed out back, a couple doors down. And the surveyors was out there doing a survey. And there was, one stake was missing out front of between my house and his cousin's house. And the one out back, the surveyor says, here's your stake out back, because he had to go across my property to the road to survey that. And at the time, he's the one that surveyed the lot, you know, the company was the one that surveyed the lots to all the lots in there. And he surveyed it up, made sure the stake at the corner was right. And I asked him, well, would you put something where my survey stake's supposed to be? He says, yeah. He says, I'll put this little flag and this tube I got that we mark surveys at where it's supposed to be. Well, it come up missing. And then it also, then I started digging around and looking for it, and it popped back up 30 days later, and it's not in the right spot on my diagram.
Okay. So you say survey stake was gone and reappeared in the wrong spot between his cousin and my property, March 28, 2021. Is that when the stake disappeared, March 28th, or when it showed up in the wrong spot?
Just a second, I got some notes here. I've been keeping pretty track of that stuff. Yeah, it was 28 there.
What happened on the 28th?
That's when I was looking for that stake.
Okay, so that's the day it disappeared. Then you wrote April 2021, lights shining toward my house on and off the whole month of April. April 30th, 2021, Walt, that's Walter Caskey Jr. Is that correct? Walt rode his lawnmower over to my neighbors, and I took pictures and reported to the police. He was too close for comfort. Are those things true?
Yes, sir. I have pictures of it. My neighbor got a picture of him sitting in the other neighbor's driveway. And I was sitting on my porch when he took off.
You also wrote, quote, heard shooting at night and sounded like it coming from his house. Not sure it's him, but sounds like it. The only reason I say this, he has told me in the past he shot a hole in his canoe. Neighbors have complained to me about him shining his lights and keeping them up all night because it bothered their dogs. Close quote. Were those things all true, sir?
Yes, sir.
Now, apart from what you wrote about Mr. Caskey these things that you think violated the personal protection order, apart from the things you wrote in your motion to have him ordered to come here and show cause why he should not be held in criminal contempt of court. Those things that you all wrote about, all of those things happened before April 4th of 2021, correct?
Yes.
Has Mr. Caskey done anything since April 4, 2021 that you think violates the personal protection order?
Just the lawnmower trick. It's,
And that
being
was-
close for comfort.
Okay, and that was something that happened with, you wrote about that
Yeah.
lawnmower incident in the motion, correct?
Yes.
So that was something that you already were aware of and had written about in the motion to show cause Mr. Caskey, right?
Yes.
What is it that he's been doing that you think violates the personal protection order?
Well, just being too close, I don't know if he's, has a gun or what's gonna happen, it's not, I feel that I should be able to do things, and my kids, my grandkids can do things and stuff like that without him after being shining lights and all that stuff all the time. We can't sit on the porch and talk because he's got his music cranked right up as loud as he can get it and stuff like that.
Is there anything else you wanted to testify to today, Mr. Brighton?
No.
Do you have any witnesses you want to call?
Would you read these letters first, Your Honor? Yeah, I got one.
Are you offering these letters as exhibits?
Yes.
Do you have an objection to those letters, Mr. Rowe?
Your Honor, I do have an objection. I haven't seen what those letters are. Who's written them and the content or subject matter of those letters.
Okay, what is it that you think the letters would show or inform me about Mr. Brighton?
It would prove that I'm not just wasting your time and lying to you or anything like that. Your
All right,
Honor.
so these are letters that.
These are witnesses. And that I guess you would say.
All right, and these are witnesses that write in the letters about the things you say Mr. Caskey has been doing from January of 2021 up until May 4 of 2021.
Yes.
So these are witnesses that wrote about what they say they saw as far as Mr. Caskey shining the lights and playing his music loud and driving his lawnmower over to your neighbor's house.
Yes.
And so these are letters that are being offered to prove the truth of what the letters say, correct?
Yes.
All right. And the objection to that is that those letters would be hearsay because they are being offered to prove the truth of something that these witnesses claim they saw. And the witnesses are not here today to testify.
I have one.
You have one of the witnesses and the others are not.
Right.
All right.
They're unable to come due to work.
Okay, I'm going to sustain the objection to the letters. And they won't be admitted into evidence because they are hearsay. But you say you do have one witness who is a neighbor of yours who is here who could testify.
Yes, I do.
All right, you want to call that witness?
Yes, Tim Judy.
Mr. Judy, would you please come forward, sir, to the far end of the bench? Take your time, sir.
Thank you. Got it back up.
Well, none of us are getting. Would you raise your right hand and be sworn, sir?
Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Could you tell us your name, sir?
Timothy Robert Judy.
You may be seated if you'd like. Your first name, Timothy, is that Timothy?
Correct, Your Honor.
And middle name is Robert,
Correct.
Robert.
Correct.
And how do you spell your last name?
Judy.
Judy. So Timothy Robert Judy.
Yes, sir.
And do you know Terrence Brighton?
Yes.
Do you also know Walter Caskey?
Yes.
The person you know as Walter Caskey or Walter Caskey Jr., is he here in the courtroom?
Yes, Your Honor.
And could you point to him, sir? Very well. The record will reflect the witness identified the defendant. How is it that you know Mr. Brighton and Mr. Caskey?
I live next door
I
to,
apologize, sir.
sorry.
I said the record will reflect you identified the defendant. Actually, the record will reflect you identified the respondent, Walter Caskey Jr. How is it that you know Mr. Caskey and Mr. Brighton, sir?
I live next door to Walter Caskey, and Terry is across the street from me, kitty corner.
So Terry.
He's offset one house.
Terrence Brighton.
Yes, he is across the street from Walt, and Walt lives next door to me.
And how long have you known Mr. Brighton?
I moved up to Harrison a little over 4 years ago.
And is that when you met Mr. Brighton?
Yes,
And how, is that the same time that you met Mr. Caskey?
yes, Your Honor.
As far as, were you aware that Mr. Brighton had gotten the PPO or personal protection against Mr. Caskey?
Yes, Your Honor.
And if from what you have seen and heard in the last 6 months, have you seen or heard anything that makes you believe Walter Caskey has violated the personal protection order?
Yes, Your Honor.
What is it that you have seen and heard?
I have witnessed the lights. This is, I don't know how much you want me to elaborate for the court, but the bottom line is that Walt has shined myself as well. I had to put up a building and so forth. This is a constant occurrence. What Mr. Brighton is saying is that it's not just one case or one episode. I had to put up a 9-foot wall building to prevent Walt from shining lights in my house, blowing dog whistles so that my dog would bark. He has cussed at me, swore at me. He has been very aggressive in his nature, to the point where I have not spoken to Walt in a very long time because I fear, the man is, he is not, in my opinion, balanced. I mean, it's like all of a sudden he becomes very explosive in nature. And this is, I believe, what Mr. Brighton is trying to convey also, being firsthand of this knowledge, is that all of a sudden he just snaps and he just will become very hostile, very aggressive in his nature and swear, shine lights. These are not just regular lights, Your Honor. These are actual, he places them in the windows on his buildings and he shines them directly into your house at night. And I have had this happen to myself also. Is in the other instance of him, which I do have a picture on my phone, is when he just drives out of his driveway, parades right past Terry's driveway and pulls into his neighbor's yard and just basically has the, well, what are you gonna do about it? Attitude.
Okay, and when you referred to these lights, are these search lights or what are they?
They are not yard lights. If he would have just regular lights, Your Honor, I could understand that, or even floodlights, you know, that, but he takes them, he has them directed. Mr. Brighton had to put a fence up, which he received a fine for, privacy fence, it cost a split rail fence, because Walt was shining them directly into his windows, same as he was with me. I put the building up. He put the fence up because he didn't have any other choice. You know, he's going across the street. These are floodlights, and he directs them. It's not like he has them just to light up the yard, or it's not a yard light, Your Honor. These are actual lights that are positioned, and he positions them, he adjusts them all the time to go over the fence now, around the fence, anywhere that he can squeeze it through. He puts them in his windows, and he's showing them at myself and at the Brighton house.
And you say this happens repeatedly?
Yes, he's very sly about it. What he will do is, if I believe that, I do not know, but I believe that he has a scanner, so that if Mr. Brighton calls the police or whatever, that he quickly shuts them off, or he only does it for just a short period of time so that he knows this. Terry does have pictures of the difference in the light bulb wattage. Now, he did lower the wattage on some of the bulbs when he was supposed to come to court here. And the picture that Mr. Brighton has on his phone is quite accurate. You'll see a white light taken on the date, and then later on, the lights are yellow, which indicates that they are lesser halogen bulbs. But it's with malice that he does this.
Right. And you say did these things, the shining of these lights, did that start in January or?
Oh, it started before this, Your Honor. It has been nonstop for quite some time. And even though Mr. Brighton progressed to get to the PPO order, it has not stopped.
All right. And so during the month of January, Terrence Brighton was shining these lights, I'm sorry, Walter Caskey was shining these lights onto the house and property of Terrence Brighton.
Yes.
And then again in February.
Yes.
And March.
Yes.
And April.
Yes, I don't know exactly when his first time was here before he changed the bulb wattage, but yes.
And then, so these things you've testified about today are all things that happened before Mr. Brighton came and filed his motion back on May 4th.
Yes, Your Honor.
Do you have any questions of this witness, Mr. Rowe?
Yes, I do. Thank you, Your Honor. Mr. JD, you said you're neighbors with Mr. Caskey.
He is my next door neighbor, correct?
Okay. And is his house across the road from Terrence Brighton's house?
Yes, his house is across the street from the Brightons.
Now, is his house, is Mr. Caskey's house right near the road, or is it offset from the road?
I'm sorry, I didn't get the question.
Okay, so is his house right near the road?
His house is in line with mine.
Okay, so is that near the road?
They're offset according to the standards required.
So how many feet offset is that?
Guesstimate,
Yeah,
the lots are 66 feet wide, 120 feet deep. The houses are smaller two-bedroom houses, roughly around 800 square feet. I would say that they are offset from the road 30 feet.
okay, 30 feet. Thank you. Now, have you seen how security lights work where they automatically turn on and off?
Yes,
Mr. Caskey's lights, do some of them act that way as if there's a motion? They turn on and then they turn off a little later on?
they come on and off at times, and at times they're on all the time. They can be controlled.
When you say they're on all the time, how long are they on?
They can be on all night.
But typically, how long are they on?
Typically, they're on, that's kind of difficult to answer because sometimes I just end up having to pull the drapes so I can get some, not blinded, but they're on longer than a regular sensor. They're on sometimes 30 minutes, sometimes an hour, sometimes 10 minutes, sometimes even only 5. It varies. It's never the same. Sometimes all night.
Okay. All right, that's all the questions I have, Mr. JD, thank you.
Thank you, sir. And Mr. Brighton, do you have any questions of Mr. Judy?
No.
Thank you, sir. You may step down, but please watch your step there.
Thank you.
Mr. Brighton, do you have any other witnesses you wanted to call, sir?
No, I don't.
All right. Mr. Rowe, apparently Mr. Brighton has rested. Do you have any witnesses you wish to call?
Mr. Caskey, Your Honor.
Mr. Caskey, would you please come forward to the far end of the bench and raise your right hand to be sworn?
I got a bad hip too.
Okay, thank you. Take your time, sir.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Could you tell us your name?
Walter James Caskey.
You may be seated, sir. Now, Mr. Caskey, I'm going to direct your attention to your lawyer, Mr. Rowe. He might have some questions of you.
Okay.
Mr. Caskey, do you have some outdoor lights?
Yes, sir, I do.
What kind of lights are they?
They're security lights. They're on motion sensors. You can buy them at the hardware store.
And
they have, I'm sorry.
Go ahead, I'm sorry.
They've got 60-watt regular indoor house light bulbs in them. They're not floodlight bulbs.
All right. Now, where do you have them placed?
I have one above outside, it's facing down in my kitchen window, 2 on my front under an eave, and 2 on a rear shed in the backyard, facing towards the ground. My brother, he's got pictures of them.
Okay. Do you have any, like, I don't know, like any searchlights in your house?
No searchlights.
Do you have any floodlights that are you put in your windows?
I had a couple lights in there and then neighbor across the street said they were pretty bright, so I took them down immediately.
Now,
The next day
which
they were
direction were
down.
these?
I'm sorry, Mr. Rowe, before we go further, when was it that your neighbor complained and when was it that you immediately took these lights down?
Your Honor, I don't know the exact dates, but I took them down the next day. I didn't realize they were that bright and I still don't
Was that
think
in the year of 2021 or was it last
20,
year?
20.
So that was way back last year.
Yes, sir.
All right. I'm sorry, Mr. Rowe, go ahead, sir.
Okay. And what direction were those lights focused at?
They were towards the front yard. I thought they were down towards the ground because they're adjustable. So in case somebody came in my driveway, they wouldn't trip in a big ditch in my front yard. They weren't purposely
What's
pointed at anybody.
Mr. Caskey, what's the length of your front yard from your house to the road?
Mr. Rowe, I really couldn't tell you. I've never really measured it up, but my cottage is set back from the road.
How can you give an estimate from your cottage to the road?
Could I ask my brother? He knows more about it. Wayne, how far do you think the cottage is from the road?
I think all cottages are about 50 feet off.
About 50 feet away from the road?
Okay. Do you go across the road to the neighbor of Mr. Brighton?
I rode my new lawnmower over there one time and I thought Mr. Brighton was gone because his truck was gone. Went over and talked to my neighbor because I hadn't seen him all winter. And he told me he was having the well guy come out and I wanted to ask the well guy some questions because I'm having well problems too. And I immediately rode home, didn't look over Mr. Brighton's house, nothing. I didn't even think he was there.
Did you push snow across the road?
Yes, I've been doing that for years before Mr. Brighton even moved up here. And I have a letter right here from my cousin.
Okay, were you pushing it onto Mr. Brighton's property?
No, sir.
Where were you pushing it to?
In my cousin's property.
Where's your cousin's property?
Right next to Mr. Brighton across the street from me.
Do you know anything about motor oil in Mr. Brighton's mailbox?
No, that's all new to me, sir. I've got pictures on my phone of where I put my used oil. It's in my rear shed in a 1-gallon jug and in an oil changing container. I drink that water. I don't dump oil on my property or anybody's property. I take and have it recycled.
Do you know anything about a survey stake of Mr. Brighton's?
No, this is all new to me. But Mr. Rowe, I think my cousins want to know where they are because I think they're going to be wanting to put a fence up.
Well, we'll let your cousins take care of that.
Yeah,
Okay?
yeah, I know.
Okay. Do you play music loudly at night?
I usually wear headphones, but no, I don't, not loud.
Okay. Your Honor, I have no further questions.
Do you have any questions of this witness, Mr. Brighton?
No, I don't.
You may step down, sir.
Okay, thank you.
Do you have any other, take your time and be careful.
No.
Sir. Do you have any other witnesses to call, Mr. Rowe?
No, Your Honor.
Do you have any other evidence to present?
No, Your Honor.
Anything further, Mr. Brighton?
No, not really. Just the houses are a little closer than they are approximately saying.
Thank you, sir. Do you have any argument you want to make, Mr. Brighton?
No, I don't think so.
And do you have any argument you wish to make, Mr. Rowe?
Your Honor, yes, I do. Court's heard Mr. Brighton state in some testimony of some complaints. Your Honor, most of those would not apply to the personal protection order. Maybe those are something that would go under a tort of a nuisance or something like that, but not under this personal protection order. I think that where Mr. Brighton saw Mr. Caskey on a lawnmower, I don't think it was intentional on Mr. Caskey's part. He said that he's a neighbor, for one thing, of Mr. Brighton, wanted to talk to another neighbor and thought that Mr. Brighton wasn't there at the time. So I don't think that he meaningfully violated the order in that aspect, because I think the appearance inside is more for harassment when taken in context with the other parts of the order that can be checked and that are in fact are checked. I don't think Mr. Caskey was trying to harass or cause any problems with Mr. Brighton. So, Your Honor, for that reason, the argument is that Mr. Caskey is innocent of violating the personal protection order.
Thank you, sir. Very well then, in this case, first, the court notes that the personal protection order, among other things, specifically provides that the respondent, Walter Caskey Jr., is prohibited from stalking Terrence Brighton, and stalking is defined under MCL, or Michigan Compiled Law 750.411 and MCL 7.411, subparagraph H and subparagraph I, includes but is not limited to following or appearing within sight of the petitioner. That does not appear to have happened here. Appearing at the workplace or the residence of the petitioner, that's not alleged to have occurred here. Approaching or confronting the petitioner in a public place or on private property, that's not alleged here. Entering onto or remaining on property owned, leased, or occupied by the petitioner, Terrence Brighton, that's not alleged here. Sending mail or other communications to the petitioner, that's not alleged here. Contacting the petitioner by telephone, that's not alleged here. Placing an object on or delivering an object to property owned, leased, or occupied by the petitioner, that's not alleged here. Threatening to kill or physically injure the petitioner, that's not alleged here. Purchasing or possessing a firearm, that's not alleged here, other than implicitly Terrence Brighton has said he has heard shooting coming from Walter Caskey's property. But, so, Mr. Caskey, I don't believe you've been confronting Mr. Brighton and he has not claimed that. I don't believe for a minute that you just have some innocuous lights that are motion detector lights that just come on as many of us do at our houses. Because both Mr. Brighton and Mr. Judy specifically testified, you have lights that are directed at your neighbors' residences. And I don't believe you are just innocently going about your business, Mr. Caskey. It's pretty obvious to me that you are doing what you can to promote Mr. Brighton. You can shake your head all you want, sir, it doesn't impress me. Frankly, I've been sitting here trying to decide whether what you've been doing is so blatant that I should hold you in criminal contempt of court. And if I did, how long I should toss you in jail for. Whether 30 days would be long enough for you to get the message or whether it should be longer. What I'm going to do is this. I'm going to give you one last chance to save yourself from having to reside in Clare County Jail for a while. I find that I think by a preponderance of the evidence, you have been violating the personal protection order. I even think and find by clear and convincing evidence, you've been violating personal protection order. As of this moment, as I sit here, giving you every single benefit of the doubt that plausibly I can give to you, I don't find it's been proven today beyond a reasonable doubt. And so I find you not guilty of criminal contempt of court. But I want you to realize, sir, you are right on the razor's edge. And it might be fun for you to go shoot off a gun in the middle of the night and harass your neighbor. It might be fun for you to shine your lights on your neighbor and harass them. But if that continues, it's going to fall within the definition of stalking. And in all likelihood, you're going to wind up guilty of criminal contempt of court. And the only question in my mind, if that happens, is whether 30 days in the Clare County Jail is going to be long enough or whether it should be 93 days. So that's where you stand. You were found not guilty today of criminal contempt of court. And you can thank your lawyer for that, for presenting a good case on your behalf. But even though this order is somewhat open-ended, and even though I have found you not guilty of the stalking for today, I'm just giving you fair notice, sir. I don't think you have completely clean hands. And if you are brought back into court, if you are proven guilty beyond a reasonable doubt, there's a high likelihood you're going to be in the county jail for a period of time. And it takes a lot right now to wind up in the county jail. We're getting over the COVID-19 pandemic, but it's still a problem. And it takes a lot to talk yourself into jail, but you are getting there. So go home, find your own business, follow the personal protection order, and I hope you realize if you remove that survey state, not only would that be a violation of the personal protection order, but there's a criminal law in this state making it a crime to tamper with or to remove a survey state. So good luck to you, sir. Thank you for being here, Mr. Brighton. Thank you for being here, Mr.
Should I
Pace.
give this to my attorney, so this coming winter, I can push my snow on my cousin's property, and then there's no problem there?
Better talk it over with your lawyer.
Okay.
I'll-
Thank
We'll be
you.
in recess.
All right.